Sorry, I was just saying it's able to be played back. It's not being recorded, but being able to be able to be played back is fine. That's your questions. Okay.
Turn now to the main issue relating to the landscape character and the effect on the national landscape and the area of great landscape value. So the first question is in relation to the baseline for assessing the effect on the landscape, because I think there's reference to the temporary builders compound, and in the different written evidence that's given sort of more more comments or greater reference to it than in other cases. So if the appellant could set out their baseline assessment.
Yeah, that's fine. So in terms of the site itself, it obviously was formerly used as a paddock. You can see that from its framework, and there's the old building there in terms of horse stable on the site as well in that area adjacent to the drive, the road. As you are aware, I don't know whether you've actually seen the site and been up to and seen the site yourself yet.
No,
just the
surroundings.
Then when you see the site itself, you'll see that there is a large contractor's compound, which I understand is a temporary provision for the construction of the other properties that are in the locality surrounding the site. So temporary consent on that. It is an extensive construction compound. You'll see that. But my understanding is temporary. It characterises the site as it is at the moment. There's no doubt about that. But it is accepted that if you're looking at baseline, I think effectively your baseline would be assuming that the construction compound is time limited and is removed, and then you're back to the field. Having said that, what's interesting is there's temporary and temporary, and it's been there a while because obviously construction's been taking place for a while. So actually, if you look at my appendix 1, the location plan, don't necessarily need to turn it up, but if you scrutinise the OS base for the site, you will see that there is a dashed line around the construction that identifies the construction compound. So it's obviously become a bit more feature than just temporary, if you like. So it's appendix 1, that location plan. You can see there within the red line, you've got the horse stabling building on the southern side, and you can see there's a dash line, and that's broadly where the construction compound is located.
And that's from the OS.
That's the OS base. Yeah. So it's there, but the baseline you would take as the field. It's temporary. So the other point is that there is some it's a pile of rubbish there as well, which you'll see on site as well, which I assume is there to be carted off or burned in due course. That's just arising from construction work that's taking place. So that's
Okay.
response to your question.
Thank you, council. Any comments on that in terms of the baseline? Starting.
The council very firmly of the view that baseline is the paddock, and the constructor's compound or any rubbish piles or anything that is done to perhaps visually detract from that baseline or that piece of land should be disregarded. And as far as I'm aware, the temporary consent only arises from, I suspect, the general development order. I don't believe there has been any planning permission actively granted for temporary consent, as far as I'm aware.
I can confirm, in fact, it was approved under clearance of conditions for the two developments that are currently going on along one is the pool house and the other is the 3 cottages. So it's part of the, forgive me if I get it wrong, but the construction management plan for those two.
Yeah, that's different to granting plan. That's a little bit GPDO, and that's where they specified the construction component.
It's been in use for about 4 years, I think.
In terms of the reference to the previous two appeal decisions, I know it's identified that the surrounding area has changed since that time.
Yes.
Did you want to expand on that in terms of the?
Yes, if I may. So I would go so far as to say there's been a material change in terms of its what I would describe as development context. So if I can just explain that a little bit more. Immediately to the north, and you'll see this, just a short distance to the north, there is a public footpath which is orientated east-west, that public footpath 35. And immediately to the north of that is a former consented development known as Sturt Farm, as it was referred to in the previous appeals, now more accurately referred to as Grasslands Close. And I would encourage you to take the footpath from Hedgehog Lane westward, just to the north of the site, walk down there, and you'll get a full appreciation of the scale of that. You've
I
probably
did that
done
yesterday.
Fine.
Yeah.
So previously that was meadowland. So, and what's interesting is if you look at the designation plan, which is in my appendices, I'll give you the reference if you would like. Just bear with me. Probably the best plan, clearest plan, is my appendix 3B, which shows the policies map for the area. And you can see, hopefully you can work out which is the triangle field on there, just marked it on red on mine. But what I was just referring to in terms of Sturt Farm, you can see on the bottom of the plan where you've got the AONB, the National Landscape AGLB. It runs up to a line of houses, and the narrow field which lies between the plan, those houses on the plan, and the site was Sturt Farm, which is effectively Greenlands Close, Grasslands Close, and so all of that development sits within the AONB, the National Landscape. And the AGLB at its eastern end. So you can geo-reference that for yourself. So what we have is, you can stick with that plan for a moment actually. So the National Landscape in the AGLB extends over and wraps around the site, as you can see on this plan. That's the triangular field. You now have a scenario where you've got the residential development wrapping around the northern arc of the site, and that sits within the National Landscape and the AGLB. And also you can see on this plan, there's an indication of properties just to the southeast, to the south and to the east of the site. There are now a total of 8 large properties set within large grounds. Again, you'll see this on site. But there's a total of 8 properties as I count, that effectively wrap around the southern and the western sides of the site. So which, again, all within the National Landscape. So there is a material change in that the development context for the site now is framed by a residential area to the north, which is what I've described as medium density in broad terms. And in terms of residential development to the west and to the south, which I've described as low density. And you then have what did exist before, the existing residential properties associated with the edge of the settlement and Hedgehog Lane. Again, you can see that on the master plan and the appendices, you can see those properties on the right hand side of the plan. So you've got existing built form associated with the settlement of Haslemere immediately to the east, contiguous to the east. You've got the former Sturt Farm development, Grasslands Close to the north, and as I say, you've got the residential area to the west and to the south. So the whole site is now framed by residential development of varying densities and various plot sizes, variable plot sizes, but also, and I would ask you to note this because there's been lots of talk about self-build. And I think what comes with self-build, as I understand it as a landscape planner, is that there's often coding to give some parameters as to the types of design, style and materials that might be used within a particular enclave of development like this. But obviously there will inevitably be a degree of variability in terms of style and design. And from my perspective, that I think is absolutely fine from a character perspective, because what you will see when you look at the existing properties on Hedgehog Lane, which are old properties of last century, mid last century, early last century, you've got the modern development immediately to the north, and then you've got quite a range of architectural styles from very modern, such as the pool house, which you'll see, to something that's sort of a very classic pastiche design, in my words, in terms of Longdean Hall. And then you've got a very traditional design in terms of the main house, Longdean House. And then you've got effectively more contemporary design with a twist of traditional design with regard to the new 4 detached properties that have been built just to the west. So there is quite a range in terms of the sizes of the units, the density and the styles that now surround the site. I'll pause there.
Thank you.
The council take the different view and argue that the surroundings have not materially changed since the result of the previous appeal. The previous appeal went at great lengths to understand the visual relationship between the site and the surrounding area, and how the site forms part of the grounds of Longdean House. In particular, if I could draw your attention to paragraph 16 of the appeal decision from 2023. Mr. Allen, Martin Allen was the inspector. It's page 3 of that decision. Page 3. So the inspector clearly notes that he was aware of the development of Scrap Farm to the north, and also commented, as you have seen on site, that it has little visual relationship with the appeal site. Despite its proximity, there is a footpath and a narrow parcel of land that lie between the two sites, and the Scrap Farm is at a lower level. And he goes on to comment that there's a significant amount of screening, existing vegetation, and moreover, to the west and south remain undeveloped because the appeal site is not surrounded by development as has been contended. That is still the case for the council's position. I think I don't need to go through the whole of that appeal decision, but it takes great length to comment on the appeal site, the surrounding area, and how the site is part of that area, and the council doesn't contend that it is now surrounded on all sides by residential development. Whilst there have been some additional, I think there's only 1 or 2 other additional planning applications that have affected Longdean House since the previous appeal decision. They are to the rear of Longdean House, i.e. to the southwestern side of Longdean House, and therefore they would have very little impact, if any, on how the site is viewed and the character of the site and the role the site plays in itself and as part of the grounds of Longdean House, as specified or as commented by the inspector in 2022.
We can just come back on that and when you finish your note. I think it's fair to say that Hedgehog wasn't, you weren't involved in 2023, were you?
No.
So, but Mr. Cook, I think you did see the site then, you have seen it now.
Yeah.
So I don't know whether that helps you. or analysis of how it's changed on the
Yeah,
ground?
so it's materially different. I would say back then, it was very the case that you had the main driveway leading up to Longdean House, and that was the central focus, if you like. That has completely changed, as you will see, and the road now leading up to the house is effectively a road to a cul-de-sac of residential properties, and that comes across when you come to Longdean House itself, and you can see as you go around that there are 4 new properties under construction to the west of the site and to the south of the site. They form effectively a development enclave of, so I counted 8 dwellings in large curtilages, and they frame the site, and that is, it's undisputable and very clear. You'll see that on site. It's a material change from what was the context before.
I come back on that point. I would therefore, whilst I accept I wasn't here, wasn't employed by the council at that point in time, the inspector very clearly, and the planning history demonstrates that paragraphs 13 and 14. Again, he is very clear to say it was put to me at the hearing that the context of the site has changed since the other previous appeal decision. And he references the development taking place at Strutt Farm, as well as the new dwellings and replacement dwellings that have been permitted at a number of locations within the grounds of Longdean House. As a result, it was contended that the appeal site was now an island surrounded by residential development, and the surroundings of the house comprise a housing estate. So there was a different, there were already buildings on the majority of those sites that were there. And in my mind, the inspector was very aware and accurately understands the impact or the lack of impact or the lack of visibility between the appeal site and those, even though some of those hadn't been built at that time. He understood the effect of what Strutt Farm would be, and he made those comments in that appeal decision. And therefore, in paragraph 15, he said it heightens the sensitivity of the location. And he said in paragraph 14, those already permitted schemes do not, in my view, diminish the contribution the appeal site makes to the rural character of the area, including as part of the AONB. That's the end, last sentence of paragraph 14. So he's very aware of the planning history of the site and the surrounding area and what the development was like.
So what I would say is that there is a difference between understanding the context in terms of what the inspector was aware of then and what was actually on the ground. But what was actually on the ground is materially different to what's on the ground now, and you'll see that. Longdean Hall has literally just been finished very recently. The 4 detached houses are under construction. The pool house is now in place. And it has a very different look and feel to when the inspector would have appreciated the site. And that's very informative, because when you're on site, as you will appreciate, is understanding the look and feel of the character and how the actual built form, once in place, is characterised in the landscape.
Haven't quite finished, so people again, paragraph 11 of the decision, the overarching analysis, top of page 3 of the decision is the grounds are a key feature of location in reminiscence to the grounds that commonly bound large country houses. So whatever the position was before the previous inspector, that's how he read it. And really, anything to suggest to the inspector about whether now, based upon the evidence for you and the situation for you, that's the right conclusion to reach as to whether this is now reminiscent of grounds with a dominant country house or something else.
Yeah, so that's materially changed. So the approach drive to Longdean House then approached the house, and the house was the dominant defining feature in the context of the site. The driveway and the relationship with Longdean House, and the fact that you had other fields around the Longdean house and the absence of those houses which are dwellings which are now present gave it the impression of effectively a large house with an approach drive, almost set within a parkland context. And that effectively has completely been removed with the introduction of the new houses, which now are located around Longdean House to the south, to the west of the site. So that sense of a house sat within its own sort of parkland unit has fallen away, and that's very clear when you see the site and its context.
Thank you very much. I think we're getting a bit muddled on some of the detail here. I thought this might come up, so I've just prepared a summary of what Inspector Allen actually wrote. And I think it's important to read the whole of the section that he dealt with the issue, and that's in paragraphs 9 to 17 of his report, where he did reject the argument that the development side was an agreement. And if I can just read my summary, which of course you'll want to check, make sure that it's right, it's correct. He, that's Inspector Allen, considered the appeal site provides a green and verdant surrounding to Longdean House, reminiscent of grounds that commonly bound large country houses. So that would include the development site. It's not minus the development site. It could not be divorced from the surrounding area, nor from the fields in the wider area, with which it shares an infinity and with which heightens its sensitivity. There was little, if any, visual relationship between the Longdean development and the appeal site. But whereas the Longdean development would not diminish the contribution of the appeal site to the rural character of the ALNB, now national landscape, the development of the appeal site would not diminish the rural character of Longdean House. There was little visual relationship between the appeal site and Sturt Farm, and the areas to the west and south of the appeal site remain undeveloped. Thank you.
Thank you.
And that's my point, ma'am, in terms of the context aspect, south and to the west. The other thing to be mindful of is that when you're looking at landscape character, one aspect of character is the perceptual aspect, and in terms of how you appreciate character of a landscape through the five senses, the primary sense being a visual sense. After that, it's usually hearing. But the appreciation in terms of how you appreciate character is through the senses, and when you're on site, it's very clear from a visual perspective that the characterization of the land that forms the context to the site has materially changed in visual context. It's very different.
Ma'am, may I say something? I have been involved in this site for some years. I knew what the site was like in at the time of the last appeal, and I'm confident that when you go out on your site visit, you will conclude that we really cannot give any weight to the evidence I'm afraid you've just been given, because the development which is being referred to is a redevelopment. There was housing on that side. Yes, I think there are probably 2 more dwellings there. But the area of the appeal site, the driveway hasn't changed. And you've got open space on the other side of that driveway. And the two complement each other. So going up the driveway, you've got the appeal site, which was a paddock. And on the other side, an undeveloped open area where there's a little bit of regeneration trees. You only impact upon the development that's taking place when you're there, not in relation to, you don't read it together with the appeal site.
Only see, you'll see this obviously on site ultimately, but as you go down the drive, you've got the entrance on the left of the new house, which is
Not deep.
Yeah, not too prominent.
Yeah.
And so the idea that there's been no material change since the first decision obviously found in our favour, but the second decision, the Walcott decision, there's been no change, is simply not right.
I would contest that. The driveway to that house on the south side is slightly further up the driveway, and you've got quite a sort of tasteful, when I say use that term,
Sorry,
metal
what's that?
gates.
Sorry, what did you say?
I said, well, you've got some attractive gates to the to that house. That house is set well back, and it doesn't really impact very much. Yes, you see these attractive gates to the driveway, but the actual house is set well back. But you can decide when you're there.
Inspector, I've lived there since 1982. When I first acquired the property, it was a large country house surrounded in a parkland setting, as it were. To say that it's anything else but a residential development now is totally nonsense. The 4 houses that we talk about are large houses, and they didn't start until last November. They're just coming out of the ground. My house, which is Pool House, which is a very modern house, isn't quite finished yet. We're still landscape. The other house was finished some time ago. But to drive up there and make out with some sort of like pristine setting, some country estate, it doesn't look like that anymore. And I live there. I know probably better than most people in this room anyhow what it's really like.
So just following on from what's just been said there, Mark, if the access road that you take up towards the site is effectively an access road to a cul-de-sac of residential properties, albeit they're large properties within large grounds. But it forms a cul-de-sac environment, and that's how it reads in landscape planning terms now. It's materially different.
In terms of assessing the effect, I know there's different categorisations of effects at site level. I think the council have referred to it as major adverse
On the site.
on the site in some of the documentation, but then major to moderate adverse effects elsewhere. Just can you clarify what the council's view is on the effect on at the site level?
Yes. I think the reason for refusal was major adverse. That's what the council would take as the impact of the site level.
In terms of 30% of the site that falls outside of the national landscape, I know
That's the eastern part, eastern
Yeah.
part, yes.
you stated that that represents a significant proportion of the site overall. Can you clarify that point, please?
So the eastern part, apex of the site, as I refer it, eastern apex, which falls within the AGLV, it falls outside the national landscape, and that is a significant proportion of the site. You can see that on the plans, you can see that on the ground. The reference point, your geo-reference point, if you like, is that if you look at the policy plan that we were looking at earlier, you'll see that the demarcation between the national landscape and the AGLV is in fact this whole stabling. And you can see that building on the site. So that gives you a reference mark on the site as to how significant and large that area is.
Council want to respond to that point?
Yes, the council agrees. 30% is not a significant proportion of the site. If 30% is outside the national landscape, that means 70% is within the national landscape. That's well over half, that's 3/4. Maybe 3/4.
Two-thirds.
2/3.
7%.
70%, so that's the sites in the national landscape.
So
I mean, actually, also, the AGLV policy states words to the effect that there similar protection will be afforded to that land as in the national as in the AONB in the actual local plan. So it has a strong level of protection in its own right. It does go on to state, and that is until the boundary review, the Surrey Hills boundary review has been completed. It hasn't yet been completed, it's about to be submitted to the Secretary of State. I would also accept that that particular part of the AGLV has not been included for inclusion in a future national landscape.
And that's the point. I think essentially the provisions that we just heard in relation to the AGLV are essentially the holding position, pending the consideration of how much of the AGLV to bring within national landscape. But no one suggests there's a prospect that this part of the AGLV will be brought into national landscape. So the rationale for that holding position, that policy protection in relation to the AGLV, isn't engaged in the same way as it would be elsewhere. In terms of, I mean, it must say it's the first time in 20-something years at the bar I've ever heard someone argue that 30% is not a significant proportion of anything. Very surprising position, but moving away from terminology in terms of what it actually means for your assessment of the merits and impacts of this particular scheme. Probably the most significant, that's an unfortunate, the most important implication is that the more significant structure of the affordable housing element of the scheme is outside the national landscape. You see on this plan here, you see the red line. So all of that is outside. And so what the national landscape and then the sparser, less dense custom self-build units are in the national landscape. And of course, when one remembers that the existing development within Longdean is within the national landscape and therefore part of the character of the national landscape in this particular facility, the custom and self-build, the sparser units, etc., are in keeping with that character of the proximate national landscape within Longdean, Mr. Lawson's house, the other house that we've just been discussing. So that's the, so we want to, don't think to help you to debate the word significant, but that's the importance for your planning judgment, I'd suggest for you, is that the block, if you like, is outside the national landscape. Within the national landscape, it's a vernacular that is redolent, reflective of what you get in the particular vicinity of the national landscape within the Longdean area.
Can I just add to that? As far as the AGLV land is concerned, any development of that would have to be assessed against whether it is spoiling the setting of the adjacent AONB or national landscape. And if you were to stand on the site and thought, well, perhaps the building that is proposed on that site were to be developed, but not the rest of the site, which is AONB, it would directly impact and spoil the setting of the national landscape. So I think in the round, you just need to take into account these are highly protected. This is a highly protected landscape.
May I come back on the other points in a minute? So reference to it being a highly protected landscape, let's deal with that point first. That doesn't mean that there is a complete bar to residential development within the designation, within either designations. In my appendices, I've got a plan. Just turn up if I may. Which is unlocked in the last appendices.
Which one's that?
It's appendix 16. Second grain. And this shows the existing footprint of development across the area. Not only the settlement, but also the surrounding national landscape and AGLV. And you can see where the site is, and you can see where the proposed dwellings are located with the red footprints. You can now see what we're talking about in terms of the context of the settlement pattern and footprints and grain of residential development to the surrounding the site to the east, Sturt Farm to the north, and the more recently consented and constructed dwellings located to the west and to the south. But what is interesting on this plan is if you were to georeference this with an earlier appendices, which shows the extent of the designation from the environmental designations plan, I can just point out a few things with reference to this plan while we've got it open. First of all, that linear development to the north of the site sits within the national landscape. That characterises the context of the site in terms of the national landscape locally, as does the 8 GEMS units immediate to the west and to the south of the red line. But if you move further west, on the plan, you can see there's a ghost wording of the word just south of the site and Sturt Farm. It says Camelsdale, if you see that. And to the west of that, you see effectively there is a high density and line of housing coming northwestward towards the settlement that falls within the national landscape. To the south of Camelsdale on this plan, you can see there's a cluster of buildings. Some with larger footprints, they sit within the national landscape. And just I would say to the southeast of the Camelsdale word is Dean End Farm, which has been recently consented for 11 units in the national landscape. And then if you go due east of Camelsdale, you'll see the dark footprints of the dwellings wrapping around the western and the southern side of that existing grain of the settlement is Scotland Park, which was referenced earlier for, I believe 111 units, again in the national landscape. So collectively, when you look at the immediate and the wider wider context of the national landscape and indeed the AGLV locally, residential development, either extant or under construction or with permission, characterises and is a feature of the local environment as far as the national landscape is concerned, as it interfaces with the settlement of Haslemere. And that's not too surprising, because where you have a settlement and then you've got landscape designations next to it, there often isn't abrupt line, but there is effectively a transition as you go from urban area into a peri-urban, urban fringe environment into the countryside. And that peri-urban and fringe environment here happens to be a national landscape where you've got development effectively falling into that designation around the environment around the margins of the settlement. So it's a very strong characteristic And you can best appreciate that by looking at this plan and marrying it up with the designation plan for the national landscape.
I was talking about these. If you were to follow that argument, one can anticipate that if permission is granted for this appeal development, the same argument would be put with even more force in the development of a field on the other side of the driveway. And the whole integrity of the Surrey Hills National Landscape, I would suggest, is seriously undermined. There are always within a protected landscape settlements and the odd bit of development where there has been some new development other than Sturt Farm, although a little bit of Sturt Farm is redevelopment, but there's that one just to the south, that is redevelopment. You know, I think there was reference to 11 dwellings, and that was a redevelopment which can be acceptable within a national landscape.
Inspector, sorry, that's not quite correct. Dean End Farm, which is my neighbour, by the way, the majority of those 11 houses are on national landscape on paddock farm. Should give them a look.
No, I don't. I don't agree. When I was consulted on the application,
Greenfield.
it was not greenfield. There were buildings on it.
Well, you're wrong. I'm sorry, Inspector. You're totally wrong. There were 4 houses in a barn. The rest were built on what was paddock. As I said, it used to belong to Brenda Birth. I used to go there for parties, cocktails, for dinner. I know the land personally. And in fact, there's there was a pre-application made recently, put more houses on the paddock. And I think it was for another 20 houses. And that was supported by Waverley. And that is definitely paddock.
As to the other comments, I mean, obviously, we will well know, as others in this room should do, that one doesn't decide planning cases based on concern about precedent. Each case turns upon the evidence, nature of the scheme, etc. So I don't more needs to be said about those kind of things.
If I just may come back on that point, I did look up Dean End permission for 11. Part of the site was PDL, and I believe part of the site was more of a ramshackle agricultural. So that site, that part may not have been PDL, but it still had structures and buildings on it. It may not be the whole site, and I can't pretend that I did print out the plan to have a look, but I will try and find it. But I think the point I was going to make, which Mrs. Smith made, was that many of those sites in the locality did have existing buildings on them, and will always, you know, the national landscape, you know, abuts up to the fringe of settlement, or abuts up to the settlement. And I think what Mr. Cook said is that that just demonstrates that the council doesn't have a blanket approach to no development in the national landscape. It carefully considers each application on its own merits.
But the position, Mark, is that in terms of both Dean End Farm and Scotland Park, you have residential units located on greenfield location in the national landscape. And collectively, together with Sturt Park, they characterise the local area of the national landscape.
Thank you.
I did have a point on wanted to just go to the reason for refusal in terms of an observation, but I can do that at the end after your questions if I may. It's just put a flag on
If
the marker.
it's there now, by all means.
If I may. So looking at the wording of the reason for refusal, and we know that wording is critical under the requirements for clarity on decision notices. It's very clear that it talks about the introduction of the built form with regard to the site would have an adverse effect, major adverse effect that the council alleging with regard to the site. On its, in terms of, talks about the site and its landscape character. So the first part, as I read it, is harm to the landscape character of the site. There is no alleged harm to the general visual amenity of the area in terms of appearance. It's so character and appearance are two different things. No suggestion here that there is harm to the general visual amenity of the area, either in terms of the site or of the wider national landscape or AGL. The reason for refusal is absolutely specific, that the alleged harm relates to harm to the landscape character. So just taking those two parts then, we're talking about the site and the wider area. If we look at the site, the right thing to do, the appropriate thing to do as per best practice when undertaking an assessment of harm to character is to look at the landscape elements of the host landscape, and that's set out in my section 6 of my proof. And there I look at the various elements of the site, which collectively, that's the pasture, the hedgerows, the boundary trees, the arrangement of the field, collectively define the character of the site. So that's section 6. So what I've sought to do there is look at the elements that collectively have a bearing upon the character. So very quickly, just going through that, if we look at the different elements, hedgerows, we know we've got perimeter hedgerows around the edge of the triangular field. But as the illustrative master planners show with the outline, is that there is plenty of opportunity to introduce further hedgerows, both associated with the front gardens and curtilages, but also division between the curtilages. So there is every opportunity to have a net major beneficial effect in terms of the hedgerow resource on the site. And that similarly applies to tree cover. The scheme will involve the loss of no trees to accommodate the scheme. The arboricultural officer has raised no objection to the scheme in terms of loss of trees, because there are none. But again, this scheme, because it's a very relaxed density and informal arrangement in terms of its layout, provides the opportunity for a significant number of trees to be introduced as part of the residential development. Again, introducing a benefit and an increase in the tree resource, which we know is a character of the locality. Clearly, with the scheme, there would be the loss of the grassland and the land cover. Given you take the baseline as a meadow. However, as the master plan shows, a significant proportion of the site could remain as grassland, given its various forms of grassland. Topography, there's a gentle slope from the southern side with a fall northwards, as you'll see on the site. It's a very gentle fall. That's legibility, because there would be minimal earthworks, as we heard earlier, to facilitate the proposed scheme, even as it's anticipated as an outline. There would be minimal cut and fill required across, and therefore the general legibility of being able to appreciate the fall across the site would continue to remain with the scheme in place. There is no public right of way directly affected by the scheme, but what the scheme would introduce is further public access into the site and also recreational opportunities. So you're increasing public access and recreational opportunities slightly on the site. So that's a gain. So what I'm saying is that when you look at the character of the site, with the, as we know the character now, with the proposed residential scheme in place, the question is, where is the harm to individual features that collectively characterize the site? And that's the pasture. The other elements, there is the opportunity to actually enhance. So I would argue that there is enhancement capable of being introduced, back to the fact it's a national landscape. There is the opportunity with quality design that is reflective of the area, not only the settlement, but also the national landscape, and with the green infrastructure to introduce some enhancement, as well as conserving the overall integrity of that field unit in terms of its legibility. So that leads on to the final point here, which I wanted to make, is that back to the reason for refusal, it talks about moderate harm for the character of the national landscape. And we know that this is beyond the bounds of the site in terms of how the reason for refusal is drafted, because we've just dealt with the site on the part A of the refusal. Part B of the refusal is about the two designation. So my question I would like to put to the council through you is this, that we know that the council are alleging no harm in visual amenity terms. That's either based on two scenarios, either the proposed scheme would not be visible from anywhere and therefore would have no visual effect, or if there was some opportunity to see some cheat views, filter views of some of the roofscape, that would not in itself be unacceptably harmful in a context where there is settlement. But on either count, there is no harm that is alleged by the council. So when we think about harm to the character of the surrounding designation, the harm to the surrounding designation has to come about in two ways, either through direct harm, which is physical change to the character of the surrounding landscape. That could be like off-site works, highways, pedestrian crossings introduced, new highway junctions. I think, for example, with Dean End Farm, with Scotland Park, there is a fairly substantive access arrangement going in on that. But with this scheme, imagine the proposal in place, the character of the residential area and the landscape surrounding the site does not physically change with the scheme in place. So the other way in which harm can come about as a consequence of the proposal is through indirect effects, through visual influence and visual harm. But we know that the council have raised no harm, have raised no concern with regard to any visual amenity effects that might flow from this scheme. And that falls into the acceptable camp. So the point I would make is that, as you will see when you're on site and driving around the area, looking towards the site from the surrounding area, from the designated and from the townscape, is you would be very hard pushed to be able to observe this scheme in place. It's visually contained, highly visually contained. So it's not having a visual bearing upon the surrounding landscape. If it's not having a visual bearing upon the surrounding designation, and it's not having a physical bearing upon the surrounding designation, by definition, it cannot be harmfully affecting the character of the area beyond the site. And that, I would maintain, is the correct analysis, because the site is so highly visually and physically contained by its framework that must be the case, that the surrounding character of the designation would effectively remain and prevail with the scheme in place. And so back to the question I would like to put to the council through yourself, Mark, if I may, is that the council are alleging moderate harm to the designation beyond the site. Where does the harm flow from? From what? Because I can't see any.
Yes, shall I respond? When the local planning authority determined the application, it was before the new management plan came into being. That wasn't until just before Christmas, most local authorities finally adopted it in January. Now, there is a policy that has been introduced in that new management plan to counter the very arguments that you're hearing today, and that is policy P4. And the background to that is that the Surrey Hills is the most wooded landscape of the 34 national landscapes in the country. And if you use the argument that a development would be well screened either through existing screening or proposed screening, particularly the former, that argument could be applied masses of places across the Surrey Hills, and probably with even more force than is being argued today. They're besides, surrounded by woodlands, or even within a part of a woodland. So if I can just read out to you what the policy says, well, you've probably got it there, haven't
I've
you?
got it, yes.
And I think it might be helpful for others to hear this. Applications must be supported and with additional reasoning and justification which demonstrates that development will conserve and enhance the natural beauty of the natural landscape. Here they're talking about harm. The test is conserve and enhance the natural beauty of the landscape without relying upon existing trees and woodlands for screening purposes. Development that would fail to conserve and enhance the natural beauty of the landscape in line with national policy and the Levelling Up and Regeneration Act 2023 will be resisted even when well screened. So I think that is a new, very material planning consideration that negates most of the arguments that are being forwarded to you today. And it's going to be very difficult for you to come to a different conclusion on the value of this part of the Surrey Hills from the very forceful arguments you had for the two previous inspectors. I mean, there hasn't been so much change. I mean, I think in the final analysis, you may have to accept that, but judge the proposals against whether there are very special circumstances that are being put forward, like the affordable housing, whether that outweighs the great weight that the NPPF, the local plan, the management plan imposes to conserving and enhancing the natural beauty and amenity of the Surrey Hills National Landscape.
Few points in response. So firstly, obviously this is not a green belt, so there's no requirement for very special circumstances. Suggesting that it does obviously must be a reason for exercising some caution to what you've just heard, because that's a fundamental misunderstanding of policy.
Well, exceptional circumstances.
It's my turn to speak now.
Exception.
My turn to speak now. Then secondly, Madam, P4 is dealing with screening. One screens against visual impacts. The allegation to us is not about visual impact, about landscape character. So P4, even at its very highest, as put by Mr. Smith, doesn't actually assist on the landscape character issues that we're referring to. In any event, this is not part of the development plan, and the local plan regulations 2012, town country planning, local planning regulations 2012, which were in force at the time of this, are clear in this case law on this, which had this point been made earlier, I would have thought you could probably be aware of it. Case law that something which has not been submitted for examination and testing for soundness cannot be treated as a rule setting. That's unlawful. There's a case called William Davis, amongst others, because at the time, relevant policies, now obviously the provision now has been superseded a couple of months ago, but the local plan regulations 2012 regulation 5 made clear that a rulemaking document has to be put forward as a development plan document, so it can be scrutinised before it's given rulemaking effect. And were this policy to have been scrutinised, if it is being said that this policy demands that one ignores existing trees and woodlands for all purposes, there's no way that this 5 sounds observed. Contrary to the Glivian methodology, for the start. Clearly, one has to have regard as a matter of weight to how secure is any screening. Is for example, elm disease or anything like that, not elm disease, what's ash dieback not in Holland, ash dieback, which may mean that there's a risk that screening might no longer prevail. But the idea that one ignores all trees and woodlands, that's seriously what's being suggested. P4 demands. A, that's not a proper reading of the policy, but B, it demonstrates the limited weight that given something that hasn't been tested.
Can I just come back on that?
Yes. Yeah, I'm finished.
Just
The-
bear with us a second, they just finished their point.
Oh, sorry.
Thank you.
Thank you, Tom. So a couple of points. I think there are double standards at play in terms of what we just heard from the landscape and national landscape officer. In that we heard a few weeks ago how Longdean Hall we heard was set back, not visible, and was set back from the road, and that was considered acceptable, and that was all predicated on the premise of lack of visibility. That's the first point. The second point I would make is that there is a general direction of travel as far as the current NPPF is concerned, that one looks to try and accommodate development in areas of lesser environmental sensitivity, if I can put it in broad terms like that. And the point I would ask you to note when you're on site is that we have this site, as Mr. Banner was just showing, where you've got the eastern third of the site falls within the AGLV, and then the western 2/3 falls within the national landscape. And there's no intention, we've heard from the national landscape officer that there's no intention for that to change anytime soon. But my question, when I look and I stand in that field, we're back to the baseline, take it as a field, without the construction compound, is that when you stood there and you look at the eastern half of the field, and that's an AGLV, and that's not considered worthy of the high standards in terms of being designated as national landscape from A and B. And yet, when you look to your west, this is considered A1B. There is no demarcation in terms of that boundary between the designations as you stand in the field. And as you look at the field, the character of the east is the same as the character of the west. So my point is that in looking at this, if you consider that the eastern half is an AGLV and not considered appropriate of a high enough standard for the national landscape, then why would the area to the west be in the national landscape? It is what it is, it's designated. But my question goes to the point about the actual quality of that environment. Is it any materially different to the AGLV that you stood on one side and you can take two paces and be in the national landscape? To me, it's homogeneous, it's of the same standard. And my point is that if you've got a lower, if I can put it like this, a lower standard of quality in terms of it's not a statutory but a non-statutory landscape protection designation, then that seems that it's more consistent with the rest of the field.
Just one last point, Madam. It was said you should follow previous decisions. I'm going to come back at the end. You've picked up along the way where we say that parties. I want to make some submissions to you at the end on that. But you may have noticed from the appearances list of the second, so not the Ken Barton case in which we won, but the John Woolcott decision in which we lose, that Mr. Cook gave evidence for counsel in that case, page 11. And obviously he's giving evidence for the appellant here. And I perhaps invite Mr. Cook just to explain how it is that you feel professionally able to do that, if that may help an understanding of the differences between why therefore this case needs to be looked on its own merits rather than simply a cookie cutter approach.
Yeah, excuse the pun. So the point I would make, I think we've already touched on this, I'll be brief, is that when I was as a witness for the council at the time, the development context was very different. It was a driveway approach to a main house set within a landscape framework which read as a parkland to the main house, the main event. That is very different, as you will see walking around the site and the surroundings this afternoon. And now there is an access road to a cul-de-sac of residential properties, albeit large and within their own grounds. So there's a fundamental change in terms of the context development context to this site in that context. And in that respect, it is that material change that's come about, which enables me to be able to present my evidence here today before you with regard to the acceptability of the affordable scheme in that context.
Yes, I'll just respond to the advice that's been given about the relevance of the management plan. The management plan went through public consultation, extensive public consultation. It was presented to 5 planning authorities involved, well, 6, including Surrey. And they made comments. It was the comments were pretty well all in support. There may be some slight tweaking to the wording, and then it went to each of the planning authorities for formal adoption, each in turn. Then, provided they all adopted it, the Surrey Hills Board adopted it, Natural England adopted it, and therefore it is very much a material planning consideration. The other aspect is that if you look at the local plan policy, I think it's RE3, there is a clause there that says words to the effect that consideration will be given to the adopted A&B management plan.
So, Madam, just in response to that, just to have the references, the relevant provisions which would have been applicable at the time, regulations 5 and 6 of the town and country planning, local planning, England regulations 2012.
So, I mean, is that clause 1 in policy RE3 that ties the Surrey Hills A&B management plan into the development plan? So there is a link there, so that it gives it even more weight that is referred to in the development plan.
Can't incorporate in one through a policy, a future document in development plan. It's not how the law works. Regulations 5 and 6, the town and country planning, brackets local planning, more brackets England regulations 2012, as interpreted by, and again, if this point had been made in advance, I would have provided it, as interpreted by the High Court in Skipton Properties Limited versus Craven District Council, 2017, JPL 825, and William Davis Limited, the Sharnwood Borough Council, 2017, EWHC 3006, and in each case, the court held that something which had not been put forward as a so something that was to be put forward and relied upon as a rulemaking document must be put forward as a development plan document. And the consequence of that, again, there's a whole load of case law on this. The consequence of that is something which didn't go through that process can't be treated as if it had done. So it's indicative that the weight can only be limited.
I think if the council had counsel to advise it on legal provisions like that, I think they could well have come up with a counter argument to that one. All I'm saying is that the management plan is tied into the development plan.
If you comments on that.
So, Mark, if I may, My question that I put through you and to the council is, what is the harm of surrounding landscape? Because as far as I'm aware, it's not articulated in evidence that we've had from the council statement.
Do you want to respond to that point? I mean, I noticed that there is varying assessments of harm as well against the national landscape in the council's written evidence. I think it refers to significant somewhere, but different assessment elsewhere. Moderate and then significant. So could you clarify what the council's views are in terms of the harm to the designations and the level of harm?
Yeah.
Council.
So the officer report does go through the LVIA that was submitted with the application, which was noted in the one that was submitted with the appeal, doesn't confirm different conclusions. And it goes through, unfortunately, they're not paragraph numbers, it goes through different concepts in terms of hedgerows, trees, paddock, field, topographical field, landscape character, and then I appreciate it does seem to include public views, kind of as it's going through the character elements, and then there's a couple of paragraphs regarding views. However, in terms of the reason for refusal, it's clear in my mind that and I think this is apart from the matter we dealt with earlier, where it said I did have major to moderate. Clearly, the reason for refusal refers to major adverse effect on the landscape character, and that is referred to in the officer report.
Sorry, I'll just qualify, sorry, interrupt. I understand reading the reason for refusal, the major relates to the site.
I haven't finished yet.
So, what is?
And then it goes on to talk about a moderate adverse impact on Surrey Hill National Landscape and HDRB, and it continues further, so it fails to conserve or enhance the landscape and scenic beauty of the national landscape. And I think looking at the appeal decision in 2023, again, in paragraph 11, the inspector acknowledged that public views proposed development to be limited, but then discusses the remainder of the appeal decision, and also the officer report is regarding the landscape character in terms of the loss of the hedgerow, the paddock, the field, sweeping away of the paddock and field, and the change to the landscape character of that area. And there is a paragraph on landscape character in the officer report, where again it uses some of the appeal decision quotes in terms of the major effect on the site's landscape character.
If you finish, I think I read the inspector's question, well, I thought the question was really posing whether, based upon the circumstances they are now and the appeal that's before you now, whether and how the landscape character outside the site of the national landscape is affected. Can council articulate how, other than on the site, the landscape character, the national landscape is affected, and how? And that's on how I understood the question to be.
But the site itself is part of the national landscape.
Let's not answer the question. If I may say something like that. Okay,
Well, if you're going to interrupt me every time I pause.
Well, it's not an answer question, is it?
So the officer report considers the site in and of its surroundings as well as the appeal site as well. So landscape character is landscape on the appeal site and the immediate environs around it, which is comments on, and again, whether or not he uses from the previous inspector's report, that is still his analysis of the current situation on that site and that surrounding area. And to respond to one of the points that Mr. Cook made, he argued that because the part of the site that's not within the national landscape the part that's in the AGLB, that the part that's within the national landscape is very similar to the part outside the national landscape, that the site shouldn't be in the national landscape. We're not redesignating the national landscape as part of this appeal, and it will work both ways. If that appeal site, part of that appeal site, is within the national landscape that has the same characteristics as the AGLB, then that has the policy protection, and the argument would go the other way as well. That site should be, I appreciate it's not being designated, but therefore that's justifying the protection that the policy gives it. There are some other points I do wish to make as well.
Just if you can respond on that, Mr. Cook, come back with it. I don't hear any articulation of how the character beyond the site is affected. In terms of the site itself post-development, and the national landscape designation will continue to apply, as it does in relation, as it will in relation to Scotland Park, in relation to the rest of Longdean, etc. That's beneficial, and that will ensure the long-term preservation of the area. So, for example, in terms of any applications for extensions, that sort of thing, any applications for changes to those dwellings in future, they reserve matters. All of that will have to take into account the national landscape designation. So that's a positive. And for the reason Mr. Cook's explained, the area of the development that will be within the national landscape will be consistent with the immediate locality of the national landscape at Longdean as well. So there's nothing inconsistent with our case of an ongoing designation of that part of the site as national landscape.
Do you want to raise some points?
Yes. So and also coming back to that, there is a paragraph within the officer report that deals with the impact on.
Sorry, what are you referring to now? What document are you in?
Officer's report.
Okay, to the scheme.
Yes.
Yeah, thank you.
Relating to the impact on the national landscape, geological and physiographical features and landscape character. In terms of that's where the justification for them, or that's where the assessment in terms of the moderate adverse impact happens. It would disrupt the secluded, largely unsettled field, not in keeping with the distinctive pattern and character of the existing settlement in the surrounding area. So in terms of, there were quite a few other points that were made. The LVIA submitted particularly relies on enhancements, landscape enhancements, and the council's position, the council considers that that is an overstatement of what those landscape enhancements are. There's also a difference between mitigation and enhancements. In mitigation is required to make good farming acceptable, and enhancements are perhaps add-ons, if you like, if they can be considered and given weight in the balancing exercise if they can be secured. However, in this particular case, we've got an outline application where layout and landscaping are reserved matters. We have no indicative landscape plan. Whilst the appellant has talked about potential for tree planting and hedgerow planting within the curtilages, within the curtilages, it's not clear that given the high degree of natural landscaping on the site and surrounding the site, that would actually justify to secure additional enhancements over and above perhaps the retention of that very existing and mature landscaping. And I think there is therefore significant uncertainty regarding that, and I think natural vegetation, I think it's stated in all the submissions, provides a strong visual containment to the site. So therefore, I think that's a very serious consideration as to whether or not enhancements can be achieved on that site. Whilst the application is being outlined, if planning permission were granted, there would be nothing to stop an individual person who may have self-built the plot from submitting a brand new application. And the application, they don't have to follow the reserved matters procedure. If they are self-built, they'll be able to claim BMG exemption. If they're self-builders, they will argue that the site is well contained, it's got existing natural landscaping, and whether or not on an individual site plot basis there would actually be justification for the council to impose conditions that meet the tests of doing PPF. I think it's highly questionable. And I say that as being a development management practitioner for nearly 30 years. I think they are overestimated, and I think the LVIA in many of its sections uses the landscape enhancements and it refers to the word could be, can be. There is no certainty regarding that, and uses those landscaping enhancements to reduce the level of harm given to the landscape character. The couple of other points I just would like to make as well. The open space on the site is less than half than was proposed in the previous appeal scheme. The proposed open space now is approximately 324 square metres of open space. So that's less open space than was previously. So previously there was 535 square metres of open space and 168 square metres of play space. So the play space was different if you look at the layout from the previous appeal scheme, and they totaled 703 square metres. So there is a significant reduction in the provision of open space. Whilst the application is in outline, the site coverage of the dwellings as shown on the indicative layout is only very small. There is not much difference between totality in the previous scheme and in the current scheme. It's around 112 square metres, but I do accept there is an outline, and Mr. Banner referred to the apartment block being larger than, or an apartment block that is larger than the one that was shown on the previous indicative appeal scheme. And there are also 3 dwellings proposed, three self-built plots rather, proposed to the southern part of the site, whereas before there was open to, because you had more open space on that southern aspect of the site. So I think also there have been changes to the appeal scheme that are different to the previous appeal scheme. Perhaps lastly for this section, the appellants clearly also refer to other appeal decisions, and most notably Scotland Park. Scotland Park is a completely different scheme. It has a completely different number of dwellings. I think it's, it was a major scheme in the Surrey Hills National Landscape. It's more difficult to find alternative sites for larger schemes. It's 111 dwellings, I believe. I believe it's outlined. I think Mr. Banner is obviously was involved in that site, and they have significant substantial open space, SAN forests for the benefits of that development far outweigh the potential could enhance some additional landscape scheme. So whilst Scotland Park has been referenced a lot in terms of the benefits and the enhancements, that scheme is incomparable to the current appeal scheme.
If I can come back initially on some of those, but
I'm just wondering whether, something also to the council, whether I can add to what the council's saying, and then you can come back on what we've jointly said. Is that acceptable?
Are you responding to those points?
I was going to respond quite specifically actually to a couple of points,
Yes.
but if I may. It was a large part of what we just heard concerns the point which was contentious also in the Office Board that committee about what reliance can be placed upon mitigation measure planting. And it was said, well, there's a lot of reference to could and no certainty. And that's fundamentally a misunderstanding of the test at the outline stage. Because at the outline stage, the test in law is could an acceptable reserve matter scheme come forward? Not will this particular one or that particular one. Are you satisfied that an acceptable scheme could come forward? And if you are, then the council has within its powers the ability to scrutinise and regulate at the reserve matter stage and ensure one can come forward. So the suggestion that there needs to be certainty and that could isn't enough is fundamentally wrong in law and unreasonable. Secondly, a point was made in a similar vein that there's something inherently problematic about the landscaping being reserve matters. I think you may well be aware of this already, but the law gave the council the ability to request full details. Article 5, paragraph 2 of the Development Management Procedure Order says this. It says, and you've got to get this on my way, where the authority who are to determine application for outline permission are of the opinion that in the circumstance of the case, the application ought not to be considered separate from any or the reserved matters. They must, not may, must, within the period of 1 month, beginning with the date of receipt of the application, notify the applicant that they're unable to determine it unless further details are submitted, specifying the further details they require. So it's simply not open to the council now to complain about the outline nature of any of the matters that are reserved and take any sort of point that the lack of specific details means there's no certainty, when it was under a legal duty, not a power, but a duty, word must, to exercise that power had it thought was deficient. It's fundamentally inconsistent with the council's failure to exercise that duty to take the points that we just heard. Scotland Park and Knowledge Museum Cook.
I've got 3 short points, if I may, in response to the points that have just been made. First of all, the LVI, of which I was co-author, it can only refer to could. The points that Mr. Barnes just made out. The application was in outline, and therefore it's setting out the prospects of what could be achieved, rather than definitively. And the other point, which sits alongside that, is that there was no request at any point from the council to provide further level of detailed information to support their determination of the scheme, which has just been made. I think it's common ground between the parties that the site benefits from a high degree of physical and visual containment. And you'll get the measure of that when you're on site, Mark. But the point I would make is that because it benefits from a high degree of containment because of the mature hedgerows and trees around the perimeter of the site, that is what I would describe as effectively integral mitigation. It's mitigating for any potential harm that might flow in terms of visual effects and character effects beyond the site. So no mitigation per se is required because of its physical framework. However, within the framework of the site itself, there is the opportunity to introduce green infrastructure to articulate and create spatial definition for the individual curtilages. And that, by definition, must be enhancement because it's not mitigated. That's the enhancement element, reinforcing the wooded character of the locality. The last point I'll just briefly make is that there was reference to a smaller provision of public open space. Previous scheme was significantly larger in number of dwellings and anticipated population within the site. So the public open space is proportionate to the reduced scale of the proposed development.
Yes, that's one. I think we need to look back at what the last inspector said in response to the question that Alex had put to the council. Can I just refer to, have you got that appeal decision?
Yes, yeah.
Okay. If you look at paragraph, I'm going to refer to paragraphs 18, 19 and the last part of 20. 18 says the appeal scheme results in the introduction of 16 dwellings at this location. This is for 14 dwellings. In my view, this would have an unacceptably deleterious effect on the rural character and appearance of the site and the surrounding area. This includes diminishing the contribution that the site makes as part of the AONB. Now, when you look at the site at the moment, you're looking at a field, but under this, there will be developments which will be higher and therefore it is possible that the roofs or some aspects of the development may be seen, but you only need to glimpse or be conscious of the fact that there is development there to know that it is having an effect on the value of the land, of that landscape. In times of darkness, there'll be lights. There may be a glow coming from the site. And there will be activity. The tranquility of the site will have been lost. Then if I go on to paragraph 19, the appellant highlighted that some development in the A and B can be acceptable and that the appeal scheme represents the least impactful development. However, I consider this underplays the significance of the effect of the proposal. And I, for the reasons I've outlined, which was earlier, that the impact of the development would be considerable. I mean, this is really forceful stuff. I just don't understand how the appellants can counter this. Then the last part of paragraph 20, this is where the second inspector was referring to the first inspector's conclusions. He says, the inspector concluded that there would be a loss of openness and local distinctiveness resulting from the introduction of an urban form of development and associated activity. These are also findings that I reach in relation to the appeal scheme that is now before me. I don't consider that there is very much difference between that development for 16 dwellings and what is before you in terms of visual impact. In some ways, actually, that might, even though there are more dwellings, I'm not certain of the various sizes, and we don't know what size in the end the self-build dwellings would be, but it could actually have a greater impact than the previous scheme. So I make those points.
I'll come back. Okay. I'm very familiar with the previous schemes for reasons that have been explained. They are different schemes, and in summary, the layout on the previous one was more fixed and a higher density. And as you look at the scheme now, on the north side of the access road, there was a continuous line of mature trees. And with the proposed scheme, those continuous line of mature trees, a number of the trees which have now succumbed to honey fungus have now been removed, but they were tall and they were visible from the northern parts of the town looking southward towards this area. So what was articulated in the inquiries was that there would be pressure for those trees on the southern side to be removed to deal with overshadowing for the property on the layout of the scheme, and therefore trees would need to be removed in due course. And by removing those tall trees, it would have an effect on you'd be able to, that legibility would be perceptible from towards this area. Roll forward to now, the lot of the trees in the immediate vicinity have been subject to honey fungus and have had to be cut down and removed, such that there's a far thinner spread of mature trees on the southern boundary, such that light and overshadowing or any sort of pressure to raise canopies or remove trees falls away, and that's borne in mind in the arboricultural officer's response with no objection. So there would be no requirement for any further tree loss if this scheme would come forward, and therefore there would be no perceptible change to distant views from the north of town looking south towards this tree skyline, which was quite characterful at the time of this decision. The second point, reference to activity, or let's deal with light spill and light pollution. Light pollution goes to visual amenity point. Visual amenity has not been raised by the council. All aspects, and even the reference to some cheap views or filtered views of roofscapes, in that scenario, again, is not alleged harm in the an articulated reason for refusal. Back to the activity and tranquility point. This access road services a cul-de-sac now, the level of activity would not be materially different with the scheme in place, particularly given its context. And the other point I would note is that the greatest level of activity one generally appreciates with the residential area is the coming and goings of vehicles and pedestrian movement. And the vast majority of that would actually be embedded and integrated into the town environment, only entering the site at the last minute. So it's not like it's going to generate a lot of traffic and pedestrian activity, because most of it would be within the urban environment and then exiting to come into the site. So I think that the level of activity that this proposal would generate would be against the baseline of this urban fringe environment.
Madam, I just want to come back on Scotland Park decision, which was said both supposed to be wholly different. There were two key points I'd like to draw attention to. Firstly, it was on any view a far more impactful development, given the nature of the site and nature of the development. So it cannot be suggested otherwise that it's far more impactful than the appeal scheme. And secondly, Madam, and it may just be worth turning it up if you have it to hand, it's appended to our I think it's appended to our hearing statement. Yeah, planning statement of case. And then the hard copy. Thank you.
Swimming.
And state. And state of case. And
Next slide.
Scotland Park Field.
that's right, Madam. And couple of points. Firstly, I'd start with note in passing at page 13, 1 through paragraph 97. There was a suggestion by the presumably the council and or objectors that the amend of duties in the Levelling Regeneration Act in relation to national landscapes required that harm to national landscape should require refusal of permission, and that was rejected by the inspector, quite rightly so. No challenge to that finding. But then, Madam, on the exception that was major development, on exceptional circumstances, paragraph 106, on the question of need and alternatives in the well-known kind of formulation for major development, which obviously this isn't, the inspector approached it in two ways. It's not right to say that the SANG was a essential feature of the inspector's reading. He went on, if you see, to say if a more restricted approach definition needs adopted, then there's also SANG. But the primary basis on which the inspector found that that part of the exceptional circumstances test was met is in that second paragraph in bullet 2 at 106. It's obvious the need in this area is not just the quantum of homes proposed in this appeal, but very significantly greater. And despite the best efforts of the council, they've had no agreement on potential alternative sites inside or outside the national landscape, no alternative sites capable of addressing the overall housing need in the area. So the primary finding of the inspector wasn't based upon different features of that case for present SANG provision or anything else. The primary basis was the need for market and here more so affordable housing in Waverley is so great, not coming back at the end, that some national landscapes are going to have to come forward and more. So it's a very significant greater than proposed, more than just Scotland Park. Goes back, if not here, then where? That when you're at a 1.28 year supply at best, plus everything else, compromise is going to have to be made. Zero harm approach won't deliver. Will end up being more 0.28 year supply if that approach is taken. And that is the rationale that is relevant to the present case. Because what the inspector is saying in Scotland Park is some national landscape is going to have to go. That was a good scheme. We say for different reasons this is a good scheme. But the principle that there's going to have to be significant housing in the national landscape because Waverley is a constrained area with heritage, green belt, national landscape and flood zone, and frankly not very much else that isn't in one of those categories. So that's
relevance. So analytically, it is of import in the present case.
Can I just comment on that last point, because I think that the inspector, although that decision wasn't challenged by Waverley, is departing from national policy relating to the protection of natural landscapes and national parks. The level of protection of both of those is the same. And there's been no indication from the government that national landscapes should play their part in providing for more housing. I've not seen any statement to that effect. And then a lot of the landscape arguments being put before you are placing great reliance on the existing trees. Trees, the life of trees rarely exceed the life of development buildings. They either become diseased, and reference has been made to some disease. And there are lots of trees now in Surrey that are being lost through disease. And then there's also the effects of man, that they want them removed. And they want them removed in order to improve people's outlook. I think if you were going to allow this scheme, there would have to be a TPO on all those trees around the site.
There is.
Oh, I'm so sorry. Right.
If I may just come back on the.
Sorry.
Just bear with me.
Sorry,
You've been waiting long.
if you could ask a question. We just heard that Scotland Park was very different to our site. It was bigger and had lots of open space and it was better. Okay. Why did the council turn it down? They refused it.
To go to a bit.
Twice. And the first inspector dismissed the appeal. There were two
Yes.
inquiries. The first appeal.
May I ask, they haven't answered the question.
Okay.
Why did Waverley turn it down? It's so much better than outside. There's a trope here. They just turn down anything, as far as I can see, that's national landscape.
Sorry, ma'am, that's clearly not correct. Mr. Bennett mentioned that he drew your attention to paragraph 97, that the council had accepted that, or the council had argued that we refuse everything to national landscape. Since I've been here every year, that's not the case. I would also, I can't answer the question regarding the Scotland Park appeals and why it ended up, but I think I would draw your attention to paragraphs 107 and 108 and 109 of that appeal, that talk about the benefits of that scheme in terms of landscape, recreational enhancement, the provision of a forest score, best guarantees this benefit, and it goes on. And it talks about saying it's required some mitigation, but there was another element that was provided on a low cost basis, a strategic mitigation elements, what very above and beyond mitigation required, but that was obviously secured for that's part of that scheme.
Just to be clear, again, that doesn't quite deal with the point, because those comments dealing with the third bullet of the exceptional circumstances test, you can see that in the way that the effect is structured. Paragraph 106, which relates to any detrimental effect on the environment, landscape and recreational opportunities, and the reference to the considerations that you just heard are in the context of that. It's not suggested that we harm recreational opportunities. We've dealt with landscape already in terms of landscape character. The key reliance that we place in Scotland Park is a different context, namely the need for the development, in particular the need for development in the designated area. As to that, you've got my submissions already, and in terms of what Mr. Smith said about government policy and national landscape, the key point is there is no prohibition in national policy in relation to residential development, certainly for minor, non-major development, for clear reasons set out in policy. And a couple of points which you may have in mind.
I'm going to revert back to my questions now, just to check where I'm. I think we've covered the majority of the questions, but there are things that I want to move on to. Are they relevant to the points just made?
Yes, so the point I was going to make, with reference to trees and that we don't, speak about rely on trees. The age of the town settlement, runs through many hundreds of years, if not longer. And when you look at section 7 of my statement, which sets out all the character assessment, the first assessment is set out in paragraph 7.7. And a series of bullet points over the page. These are all the key characteristics of the area, including the national landscape. And over the page at 7.15, you've got the key characteristics for the Hindhead wooded green sand hills, which is the local character area, all listed there. And then the wooded green sands, all the key characteristics are listed at 7.18. And if you look through those, the common theme throughout all of those key characteristics is that this is a wooded environment. It's a settled wooded environment. In other words, there are settlements surrounded by the valley and ridges and slopes of a wooded landscape. And yes, obviously trees are time limited and come and go. But the point I would make is that through time immemorial, whilst you've had settlement here, the character of the general area, and particularly surrounding the settlements, is still wooded. There is natural regeneration, there is planting. And the final point is that on the scheme, as proposed, indicatively shown, there is proposed tree planting. And by introducing the tree planting as proposed, whether it be on the margins or within the site, that provides the opportunity for age diversity and species diversity that can address the very point that was raised by the national landscape. But those key characteristics that I've just referred you to, all of those key characteristics would remain unchanged with the proposed scheme in place.
So if we can just clarify in terms of the statutory duty and the seeking to conserve and enhance. I want to clarify your. I mean, I
Yes.
appreciate you've.
So the point I would make, splitting the reason for refusal into two parts, dealing with the site and then dealing with the wider area. I'll deal with the wider area beyond the site to start with. There is no physical or visual effect upon the character beyond the site. So the conservation area, the conservation of the national landscape or the AGLB and the AGLB beyond the site is conserved with the proposed scheme in place. Then I'm going to turn to the site itself, where there's also alleged harm only to character, not visual immunity, which is appearance. So the only thing that is changing within the site itself materially is the loss of the paddock itself. The grey of the landscape in terms of the typology, the shape of the field and its characteristics around its perimeter with the hedgerows and mature trees would remain. So the legibility of reading that as a field unit would remain with the proposed scheme in place. And I've still not yet really come across a scheme where if you're looking at a greenfield location, there wouldn't be localized harm within the site itself. But the level of harm is related to the pasture and that sense of openness within the field unit. Having said that, there is the opportunity to deliver quality architecture, completely controlled by the council, quality green infrastructure associated with that architecture, again within the control of the council, within the framework of that field. So mindful that this isn't the middle of Dartmoor or Exmoor, for example, where you don't see residential development. It's a very much remote, deep countryside location. That's not the case here. This is a settled landscape in terms of its character. And so arguably by the introduction of these dwellings here, it's reflecting and in keeping with the settled quality environment within which the proposal sits.
Madam, if I could just address you very briefly from a legal perspective on the duties. As I said before, they dealt with by Philip Ware, your colleague in Scotland Park, and unlike Smith, I say lawfully, in relation to them not being a duty to avoid harm. That's not what it is. More fundamentally, though Mr. Ware rightly noted at paragraph 98 that as judgments have held, the new statutory test is more demanding than the old statutory test, which just said have regard to. Policy in the NPPF had already gone further than the statutory said. And statutory duty now is commensurate with what policy was doing already. Because policy was never simply just have regard to. There's always great weight to the relevant considerations, paragraph 189, and then obviously a higher test for major development of the system. And I'd suggest it's very telling that the NPPF has been updated, I think, twice, and there's obviously a third one in the making since the statutory test was changed. And the NPPF test hasn't changed as a result. So it must be the settled view of the government that there's no need to change policy in light of the statutory change, because policy was already there. And in that regard, there's a lot of things in the Court of Appeal judgment related to heritage policy, and you'll know this, doing heritage, that heritage policy in the NPPF is essentially a transposition of the List of Buildings Act duties, or as Lord Sales called it, a fasciculus in the Jones and Mordoon case. Not all that I covered before. The same is true essentially in relation to a national landscape policy and the upgraded duties. It transposes the statutory policy. So if you go through we need to do the 189 exercise because we were agreed that paragraph 190 on major developments doesn't apply. But if you do the factor in 189 in the context of paragraph 11 of the framework, whatever conclusion you reach, by virtue of doing that, you'll be applying the statutory duties, not a separate layer, just as is the case in relation to heritage. I think Mr. Rose wanted to add something.
Yes, can I just comment on a couple of points? The officer made some very specific points about first of all, the lack of a detailed landscape scheme. Secondly, the size of play areas, size of open space, etc., very specific points. The condition 1, which has been agreed with the local authority, requires the submission of a scheme of landscaping, layout and scale. So all of those items are in control of the local authority at the next stage. Mrs. Smith made a very good point, and it is a good point because I do live about half a mile from the site. I'm very conscious of this, about lighting. There is a condition 19 which relates to the approval of the lighting scheme. We have it on everything around us because of dark skies policy and so forth. That's perfectly normal. And in respect of the trees, first of all, there is a TPO that covers all of the surrounding trees, but there are also 2 planning conditions dealing with protection of trees. So in addition to that TPO, there are 2 specific planning conditions dealing with it, and of course, the approval of the landscaping scheme in due course. So I think all of those points can be covered at the detailed stage.
Interested part of something in this landscape character.
I think I'll have a go. I think it is a resource, the field. I think the grass, the soil beneath it, I think they're worth preserving and enhancing. Although the land has been used as a paddock in recent years, its history goes back to the 14th century, when it was part of the Sturt Farm, which was the oldest working farm in Haslemere. As far as I know, it wasn't an arable farm. It was animals. But I mean, all this can be changed. And I fail to see, personally, how putting in houses, putting in a road, putting in a block building can conserve and enhance that landscape. I think you should also bear in mind that it takes a long time to establish a mature tree, and it takes a long time to establish a mixed hedge. You're talking tens of years, and that is in the past. Today, it's generally accepted that there is a phenomenon called climate change, and that is putting severe stresses and challenges on nature. So whatever was perceived to be difficult 10 years ago is even more difficult now and will become even more difficult as the years go by. So from one of the objectors' perspectives, we think that that field is a resource, and it is a resource worth preserving. Okay.
The biggest consequence that will have for climate change is being 7 minutes walk from the train station. Making it a highly sustainable location.
Excuse me, can I come back on that? Climate change is a phenomenon that is a global issue. This country probably contributes about 1% of carbon dioxide. So this country's ability to control or even influence climate change is limited. And walking down to a station, frankly, is really very fun to do. Thank you.
Arguably, you could say the same for the national targets in a global context then.
Of course.
Okay, just moving on then, just to respond to the specific point, because I won't go into the climate change matters. But the point was made reference to there's a dichotomy between serve and enhance as a duty of the A1, as was A1B national landscape, and the introduction of residential development in a form like this. The point I would make is from a landscape planning perspective, what I would characterise one of the principal differences between a national park and a national landscape form the A1B is that A1Bs are generally more of a settled character than a national park, which is generally unsettled character. In other words, the presence and absence of human activity and habitation. And the point is that here there is national landscape and there is a management plan, but nowhere does that preclude small scale appropriate development of a quality. This is not the designation is not a bar to residential development. It is one that needs to be taken into account.
Any more comments on landscape character?
I haven't got any other points to make.
So nobody last would have a comfort break.
Yes, that's what I'm
Only said I
aiming
want quite across
towards.
all things.
Yes, sorry. Anything? Yes, interesting.
I mean, I'll get an opportunity to say my bit, will I?
I thought you'd been answering the
Well,
questions.
no, that was, I've been responding to the appellant's case, but I haven't been invited to put forward the Surrey Hills case.
You've been responding to the inspector's questions.
Yes, in responding to the inspector's questions, but I thought I would have the scope to describe to you the concerns of the Surrey Hills Board.
Is it in addition to what I've already had in writing?
Yeah, I'll try and keep it in addition.
I think we need to have a break
Yeah.
at this point. We'll come back. We'll have a break first because I am conscious of the time. So we'll have a break just for 10 minutes.
Matt and I have been some stuff.
If you wanted to cover any points that haven't been already discussed and made, then just put some time. Then I'm happy for you to do that at this point.
Well, thank you, Madam. Just by way of background, I've been in this role for 16 years. Following my retirement of head of planning, all parties, I think, had my original advice to the council on the planning application. I won't go through that, but what I am here to defend that, or to answer any questions the appellants may have, or you, Madam. One of the reasons why I had to come along at very short notice is I know that the inspector at the Scotland Park inquiry indicated he would give less evidence to less weight to the national landscape evidence because I wasn't there to defend it. Now, I agree that the proposal is not a major proposal in a national landscape, and the baseline is of an open paddock. The council's statement of case comprehensively responds to the appellant's claims and points. I strongly agree with the council's case. I thought it was very good and thorough, and it also covered. I mean, as a planner, I also agree with the other aspects of the council's case. The inspector, in dismissing the appeal for the 2021 planning application, additionally explained at length from his paragraphs 9 to 23 the substantial harm that development caused to the then AONB. Again, that was pretty thorough, and I find it very difficult for anybody to come to different conclusions in respect of the latest application. There can be no reasonable doubt that the appeal development would seriously and clearly be at odds with national and local policies for protecting national landscape. There's not sufficient difference between that appeal decision for 16 dwellings and this one for 14 dwellings to justify coming to a different conclusion to the harm to the Surrey Hills national landscape, or at least that it fails to conserve and enhance the natural beauty of the landscape. Tempting though it is to repeat the two previous inspectors' strongly expressed recognition of the landscape importance of this appeal site and the harm those developments would cause, I won't take up your time in the hearing doing that. Safe to say that from the evidence I saw before coming here today, the parents have unsuccessfully sought to rebut those consistent and strongly expressed judgments. I mean, I think that is a major test of this particular hearing. As to, are you justified in coming to any other conclusions relating to the value of the Surrey Hills national landscape and the impact that this development would have in not respecting the need to conserve and enhance its natural beauty? There is a fundamental change in the character of the site that would be undergone if it was developed in the way indicated. The new management plan policies I would invite you to look at are P1, P2, P3 and P9. I won't go through all those, but those I think are all relevant to your consideration and give a little bit more detail, a bit more flesh on the need to conserve and enhance the landscape. And I've already mentioned about policy P4 being a new policy there, and I read that out to you. This document, I'm not sure whether you've got that one. That is a summary of the management plan. The actual management plan is thicker. And you can see that on the website. And that contains reason, justification, explanatory text for the policies. And in respect of P4, the justification for that reads as follows. With the Surrey Hills being the most wooded of the national protected landscapes in the country, substantial existing or proposed tree screening is not considered to be a justification for a proposed development. If accepted, and with the demand for development being so great in the well-wooded Surrey Hills national landscape, it would be capable of being repeated too often, which would undermine the value of its nationally important landscape designation. Now, I read that out rather quickly. I hope you'll be able to look at it yourself afterwards. I mean, that is one of the major problems that we're finding in the Surrey Hills. The demand for development is so great. There are many eloquent arguments that are being put forward for development of sites. And one of those is, yes, well, you wouldn't be able to, public wouldn't be able to see the site or the development value. Scotland Park does not set a precedent or is comparable, as the proposals and circumstances were different. The benefits included extensive open space, strategic SAG, significant BNG, and a new scout hut and a forest school. Now, as the High Court has previously ruled on this site, and under NPPF paragraph 11D1, where there is a lack of a 5-year housing land supply and development plan policies are considered to be out of date, the tilted balance in favour of granting permission is not engaged where areas or assets of particular importance provides a strong reason for refusing the development proposed. So I don't think that there's little reasonable doubt that the consequences of the development of this part of the Surrey Hills National Landscape is an asset or an area of particular importance, and it provides a strong reason for refusing the development. In my view, it will all come down to whether the balance that you have to need to strike, as to whether the exceptional circumstances that the appellants are putting forward outweigh the great weight of relating to the national landscape. The government target of 300,000 dwellings a year was the same at the time of the 2 previous appeals dismissals on this site. So I don't think you can use the present government's push for more housing as being a justification of, or a new justification for the development of this site. It was the same, it's been the same for over 10 years, but it hasn't been met. And the reason it's not being met is not down to a lack of planning permissions. There are over a million dwellings in the country. And as you're a member of the Royal Town Planning Institute, you've got the latest bulletin, contains at the beginning an assessment of the supply of housing.
But moving on from landscape character to what will become another matter. So
Yeah.
I don't know whether you want to save that for
Well,
responding to the points on other matters in terms of
all right,
balance rather
okay.
than.
that was only going to be a very short point, and then I'll finish.
Right, okay.
All right.
Carry on.
So shall I just finish off? What he was saying is that there are other issues. It's more to do with land banking and economic considerations, lack of labour supply, and that of the councils that have been surveyed, only half the dwellings permitted since 2012-13 have actually been implemented. So there's still a great supply there. And one really needs to develop in the right places where it's most needed. So I come down to that final conclusion that way.
That's all my questions answered on landscape character, unless.
No,
Want to add
I
any
think
more?
those points have probably been covered, and the planning points are about to come to.
So we'll move on to other matters. Are your points related to landscape character before I move on, or are they other matters?
Generally,
Generally,
Yeah.
Do you want to go first?
yeah, that'd be great, thank you.
Okay. Hi, I'm Guy Reynolds and I live in Hedgehog Lane, Haslemere. I'd like to thank you for allowing me to address your appeal and inquiry. I'm speaking on behalf of those of my neighbours who objected to the application to build on previously undeveloped land and in this part of Surrey Hills National Landscape, as I did at the Waverley Borough Council Planning Committee on the 17th of December 2025. We were pleased when the council decided overwhelmingly to refuse the application, primarily because it would cause a major adverse effect on the landscape character of the Surrey Hills National Landscape. We wish to support that decision and ask you to dismiss this appeal. We believe the case for developing this highly protected site has been considered exhaustively by the authorities over the past 10 years, and their conclusions have always been the same. Permission should be refused because development would cause harmful damage, which would not be outweighed by any benefits. We can see no reason for departing from these conclusions and decisions as the appellants are now requesting. We have three main reasons for asking you to dismiss the appeal. They have the support of the local WBC ward councillor Nicholson, who also spoke against the application at the WBC December Planning Committee. Our reasons are as follows. First, the site fully deserves its protection as part of the national landscape. We believe it has been accepted that the landscape and scenic beauty of the site fully deserves the protection that comes from the site's location in the national landscape in the countryside outside the green belt. We believe it has been accepted that the site has a high intrinsic value. It is an attractive and unspoiled rural landscape with a rich habitat of ancient grasslands bordered by mature trees and hedges. It provides an attractive setting to Longdean House, and it sits well in its surroundings alongside a tree-lined drive, a centuries-old wood, and a parcel of rural land which separates it from the public footpath and shields it from other developments. Secondly, this protection has always been upheld by the planning authorities. Because of these characteristics, WBC consistently refused planning permission to develop the site since the first application in 2016. And its decision has been upheld by two planning inspectors, Inspector Walcott and Inspector Allen, and an earlier appeal decision by Inspector Barton was quashed following a judicial review. Both inspectors assessed the proposals thoroughly and after inspecting the site and its surroundings and reached a similar conclusions. The introduction of a built environment would cause harm to the character and appearance of the area and the national landscape. And the great weight that must be attached to this harm outweighs any benefit from the new housing. Inspector Walcott confirmed that the site relates to the rural setting of Longdean House, see paragraph 28 of his report. And Inspector Allen confirmed that development would be a discordant addition, eroding the defining rural aspect and causing loss of green and verdant surroundings of Longdean House, see paragraph 10 of his report. We believe these are significant statements. Inspector Walcott's appeal decision was confirmed by the judicial review and the Court of Appeal, and the appellants will refuse permission to appeal further to the Supreme Court. We believe WBC's refusal of application WA/2025-01986 is consistent with Inspectors Walcott and Inspectors Allen's decision, and that together they form an important precedent, which we believe deserves respect. Thirdly and finally, the affordable housing proposals do not alter the planning balance. In considering the application WA/2021/02956, which proposed a broader similar affordable housing scheme, Inspector Allen established that the planning balance was a straightforward case of considering benefits versus harm, and concluded that the cumulative benefits were insufficient to outweigh the great weight according to harming the AONB. In the present case, WBC believes additional weight cannot be given to the current affordable housing proposals because they do not comply with policy, and the custom/self-build houses cannot be classified as affordable. We certainly support the last point. It seems that the plots for these houses, which cover around 75% of the site, could be sold on the open market if they are not sold at the discounted price within a short period of 12 months. We believe the built houses could be priced at well over £1.5 million. We cannot see how they could either be affordable for people in the housing need, making a significant contribution to Haslemere's housing obligation, or as required by the latest legislation, conserve and enhance the national landscape. In conclusion, we urge you to dismiss this appeal, which we believe does not alter the arguments previously considered and accepted by the council, the government planning inspectors, and the court. We believe these arguments and those presented to you today are valid reasons for rejecting the application. Thank you.
If I can just deal with those points, I was perhaps just give you our key headlines in terms of. So what I want to do first of all is just highlight our key headlines. What's changed with the decisions? So we heard a lot about it. Well, it's just a question of cut and paste what's been said before. Let me just sort of summarise. We've got the details. Number one, this is the 100% affordable housing scheme, the exception scheme. Number two, the landscape of Long D, if I can call it that, of the grant has changed in the way that you've heard. Baseline has changed, and surroundings have changed. Sounds etc. That may cut forward further. Thirdly, the housing land supply has fundamentally changed since the last time. So the last Mr. Allen's decision letter in paragraph 32, the range 4.15 to 4.56. It's now 1.28. So less than a third. And that's a very big number in real terms, in terms of housing meeting. And that's accentuated then by the Scotland Farm decision, recognising that the shortfall and ongoing need is so great that development in the A and B NL is necessary. We've also got sustained, continued under delivery of affordable housing and customer self-build for 3 more years since 2023. Then you've also got, importantly, and seems to dealt with this in the planning statement case, the NPPF policy has changed from in 11D. Previously, the question was, is there a clear reason for refusal on footnote 7 grounds? The test now is there a strong reason for refusal on footnote 7 grounds? And the decisions your colleague Owen Woodward's in the Faversham case, which is in your appendices, makes clear that that's a change with import. It's paragraph 101 of Inspector Woodward's decision, which in the context of other footnote 7 considerations, flooding and heritage, makes clear that technical conflicts, policy conflicts are not sufficient to represent a strong reason for refusal. Must, he says, be substantive risks and harms go beyond policy. So that's a fundamental difference from previous decisions. The scheme has changed. It's now 14 rather than 16 units, and the layout's changed such that now 30% of development, including the part of the development with the more dense massing, is outside the national landscape. We have Transform and Provider as a co-applicant and co-appellant. We've heard directly from them. And we also have a situation, as Lawson said, unprecedented in his considerable experience of planning in this borough, in this area, that the town council was supported, and that's the office support votes that were by a tune of 20 to 15 more supporters than those opposing, which is of significance. So a number of factors, both in terms of baseline, in terms of proposal, in terms of policy, in terms of needs, all of which, both individually and community, it's very different, and nothing in terms of its own merits. In terms of the planning, I don't expect it's going to assist you to repeat what you've got in writing and the waiting, but the key points I would really stress are, firstly, the affordable housing. There remains a conspicuous silence from anybody else on the other side of the room, whether they accept that were this to be a 100% affordable housing, permission should be granted. 100% affordable housing, 7 minutes walk from Haslemere station, highly sustainable location, no impacts articulated beyond the site, in a context of a highly constrained borough, for the reasons you already heard, and huge unmet needs. If not here, then where? Those are the key points I'd suggest are fundamental independence. So this stands back and what a decision dismissing appeal for 100% affordable housing scheme, social district station with no external vantage points. How would that sit against current direction of travel from government? What the mathematical basis make of that? I suggest that the answer is very obvious.
Someone to express on the balancing.
Yes, and these are summarised in paragraph 126 of the 126 beyond, I guess 125 of the council statement in terms of the planning balance. So you've heard suggestions from the council that council's position is that we don't consider that landscape either around plumbing in-house or the surroundings, that when the time of the previous years have materially changed. The scheme, as we discussed, it still has the fallback now that the self-built plots can be sold on the open market. So they, in council view, are not 100% affordable. It's not 100% affordable housing scheme. Could end up with a scheme where none of those plots are having been sold for affordable or self-built plots. Whilst the MBPF policy has changed, clearly in the previous appeal decision, it's only required to consider whether it's clear reasons for refusal. He was required to consider whether or not that was actually far in advance of that clear reason. So the council position is that there is still a strong refusal for refusing the application in terms of landscape impacts on the Surrey Hills National Landscape NGLV, and assess that in the officer report. Whilst there is 14 dwellings rather than 16, and accepting that scheme is outlined, we have heard the council mentioned in terms of the very little difference in terms of site coverage and plot coverage in the scheme. The original planning statement said they expected 4 or 5 bed units. They could easily exceed the national prescribed space standard, so they could get that as larger houses. Whilst there's 14 dwellings instead of 16, so in terms of the plot coverage, it's not materially different. So the fact that there's now 14 dwellings has reduced the amount of additionality in terms of the supported living. So in the previous scheme, there was 11 affordable units and 5 self-built plots. So the 11 affordable units was 69%. But 30%, so in the 2023 appeal scheme, the 30% policy requirement for the affordable units was 5 dwellings. There were 6 extra affordable units. In the current scheme, there's 8 supported living units, which roughly amounted to 7%. So the 30% dwellings, still 5 dwellings, so it's only 3 extra affordable units. In comparison, that has reduced since the previous appeal scheme. Whilst to transform are the co-applicant, we discussed this morning that there is no absolute obligation for the land to be sold to them. From memory, I think there is provision for the council to approve an LP, but it doesn't necessarily 100% mean that it has to be sold to them. And the site location hasn't changed since the sustainability. That was considered in the previous appeal. Whilst the council recognises that there is support, it's the planning issues that are raised. There is don't know whether they were aware that some of those self-built plots can be sold on the open market. So that the support given as a backstop. I don't know if you want me to go through kind of planning balance or if you're gonna.
I was going to take most of it as read. I've got a couple of points of response.
Okay.
If I can.
I'll have a couple of points. But you want me to go first? Just to point out on the weighting. So in the 2023 appeal, the inspector concluded that overall there was substantial weight given to the benefits, but that didn't outweigh the great weight given to the harm to the landscape character impact, so Hills National Landscape. And I've just mentioned in terms of if actual affordability or the additionality in terms of affordability is less now than what's in the scheme before. Also in the original application, documentation submitted by the applicant, in their planning statement, they said the benefits as a whole, proposing the 100% affordable housing were a significant weight to be given to them. And then obviously the council has done their way up and said how that's again, that's in the council statement. Just to perhaps highlight those points.
Unless you want to study, or just help us explaining why we have different weighting structures. You've got the information you need to make the right weightings. It's very tedious. But 3 points, madam. Firstly, in terms of comparison you've made between the housing benefits now and previously, critical point that the council first addresses the housing crisis. Waverley has got substantially worse since 2023. Got the numbers in relation to housing that supply, affordable housing, planning state on the ground, to put in, shows how significantly worse affordable housing has got. Our customer self-build, again, the position is what you're aware of. Council's meant to be doing a review as they're on plan, not really even at stage 1 of that. So the crisis is only going to get worse. We don't have a up-to-date cloud-led system here in Waverley because of the situation we find ourselves in. And that's a fundamental point. The point was repeated just now that made earlier that individual plots, the customer self-build could apply for planning permission for something different. If they did, it would have to be looked at on its merits. It's hard to see how the they wouldn't be subject to the section 106 anyway, because of it by the land. I have a struggle, if I'm quite honest with you, Madam, because if an individual plot holder applied for planning permission for something different, one plot, it would very obviously raise a hillside Pilkington issue, or it would definitely hillside, as I told a number of seminars, etc. But it would render physically impossible the complete build out of the permitted scheme, thereby jeopardising the planning permission, which would be a massively fundamental material consideration in the case law on that would be a massively fundamental material consideration in the context of that application. So it's fair to say whoever did that would face a very significant uphill battle, to say the least, and beyond the national landscape, the AOD considerations too. So I'd ask you not to give that anyway. It would be looked at on its merits at the time. And then last time, I do ask you perhaps just to get a clearer position from the council. Everything you've heard just now is predicated on the council's position that this isn't 100% affordable housing. What is the council's position? This is 100% affordable housing. Would it be different, or is the council seriously suggested even 100% it would be that this would be an unacceptable scheme? I think you're entitled, we're not, you're entitled to a clear answer on this.
Appreciate we've been through this, but it would be useful if we had a clearer direction on the weighting.
I think we discussed earlier significant or substantial weight if it's 100% affordable housing, whether or not that outweighs the great weight to be given to the harm that we've discussed. It's very difficult for me to be definitive, because if an application was going to planning committee, wouldn't necessarily, as an officer, I would make recommendations, but wouldn't necessarily, subject to discussion. So there are other parties involved, and on the basis that this is being webcast, that I don't want to, prevent the council from, coming to its conclusion or its reasoned conclusion on an application that was submitted for that. In light of whether or not the council considered whether or not they could make it 100% affordable housing, in the essence of trying to work proactively and positively with applicants, I would imagine that if the case officer considered that the 100% affordable housing would outweigh the great weight to be given, they may have investigated that further with the appellant as to whether or not there was any way that the scheme could be amended to address the concerns of the council.
I would suggest that the sort of synthesis of that is the council doesn't rule out, it's right to grant a planning permission being 100% affordable housing. It doesn't say, well, it doesn't rule out. So fair.
That's a fair precedent. I wasn't involved in the original application at all in any way, shape, or form. So it is very difficult for me to try and put myself in the mind. I obviously, I think that's a fair assumption.
Thank you.
Unless you wanted to ask any question on balance. So that's all we
I've got everything in writing, I think, along with what you've both just said. Has anybody else got any comments on planning balance?
Could I just make a general comment on the planning situation? That everybody realises the importance of the national landscape, but Haslemere has a unique set of circumstances which I think should take into account. The Grasslands Close development had 300 objectives. The Scotland Park development had more or less the same 300 objectives. The two sites are about 400 yards apart. Yet only 6 people who objected to Grasslands Close objected to Scotland's Park, and 8 people from Scotland's Park objected to Grasslands Close. So this really goes to the attitude of some local people when they push back against development. They use the national landscape as a convenience, quite honestly, rather than what I believe is having true respect for it. And as I said, The sites are literally 400 yards apart. So it would appear to me that, you know, the interest lies in the developments not being in their backyard.
Anybody else want to speak on any other matters before we move on to suggested conditions? Wasn't intending on reading the conditions out word for word. Unless I need to.
No.
I
Because
I think the most recent version that you had was the agreed version.
yes, yeah. Okay. So if I just ask if anybody's got any comments to let me know on each of the conditions, so condition 1 and 2 take together because they are.
No, it's right.
Anything else?
No comments, no, sorry.
Condition 3 in terms of plan numbers, I've
I think it refers to the updated tree protection plan and the
Yes,
updated
that's-
arboricultural report that was sent in, so I think that's already, if you
Okay.
mind, I think we said we might accept that.
yes.
After the appeal, so that should be consistent.
Condition 4, I wasn't aware of the history of this really, so I just wanted to check in terms of ceasing the office use at Longdean House. It's not overly clear in there evidence for what that.
So the situation, if I may, the situation, Longdean House is currently used as offices for many self-employed people and has been for 50 years. So there's a condition that if we get consent, if you grant us consent, then before the first house can be occupied on the site that we're talking about, we'd have to cease the use of the offices, which would reduce the impact of any traffic. So the two would balance each other. So there'd be no net gain in traffic.
It's a condition recommended by the County Highway Authority in terms of traffic generation impacts.
So say the same, yeah.
Okay. Condition 5 is slightly worded differently to what Highway suggested, I think. I think they said 3 meters, specifically said 3 meters.
They did, I think that was changed to maybe allow some flexibility in terms of understanding what actual vegetation exists on there. So rather than have it a definitive absolute 3 meters, it allows some flexibility.
Yeah, with this, I think it's important to read with condition 8 as well, because I think there's a further details regarding footpaths, footways, cycle routes in there. So if you're agreeing separate details as part of that, yet you've still obliged to conform with the plan that's referred to in condition 5. What I'm wondering is if there needs to be a link up between the two conditions, so that they acknowledge that the fact that there may be updated details agreed through that, or even possibly combine the conditions, because it's all like a two-parter.
I did have a question about condition 8 in terms of whether that would be covered by layout, would it be?
Or reserve matters.
Yeah,
Yes.
as a reserve matter, whereas this one sort of relates more to access. In for pedestrian and cycle access, whereas the other one is more to do with internal layout of the site. I don't know.
I suppose it's access on the perimeter of the site, isn't it, versus, and this is talking about, I guess, still talking about within the site in terms of the cycle route, so is it still covered by that same reserve matters question?
Yeah, they kind of overlap to some extent, don't they?
And is it there's simply that there shall be a footway cycle link access points provided within the scheme, and then details of the precise route through it is dealt with through the reserve matter stage, through the site itself.
yeah, I guess if it's changed, I don't think that's going to object to that.
So,
Don't-
keep
but
condition
five,
five,
yes, yeah.
remove condition 8.
Uh,
Or did you want to combine any of the requirements of condition 8 into condition 5? It refers to the layout, the internal roads, footpaths, footways and cycle routes. To me, that's internal to the site rather than.
yes, that is internal to the site. Just trying to think in case there needs to be. Just to make sure, because I don't think there's any specification that requires layout to come first as a kind of reserved matters, whether or not they need to rather than in terms of access for construction, because bearing in mind, I don't think the road from Hedgehog Lane is a private lane. Private.
No, the
it's
outside
only-
the access is public.
Yeah.
So Hedgehog Lane is public up to
Yes.
just beyond our
The
gate.
entrance.
and
Yeah,
then
so
it's
there is
private.
part of the site that
Yeah.
is private. So I don't know whether it's worth keeping 8. Just to ensure that law of unintended consequences doesn't happen if there is a delay or they've started or phasing. But if you felt strongly that that should be removed or the footways sidewalks incorporated into condition 5,
If I may, the other point is there's the additional condition we've suggested on the appendix side about general conformity with the site layout as well. So that is already setting a sort of parameter for what the site may comprise in the future. So in terms of expectations of how that may be laid out, this sort of thing, if there's a condition you wanted to impose that deals with that and gives certainty about what the sort of layout may look like going forward, there's an option there.
I think also it might, in terms of the scheme, they are considering or suggesting that some of the individual plots may come forward as their own individual matters, so you may not have all of the access road within the site before they come forward, and then we are going to have to deal with that kind of quite tricky. So
Sort of phased.
yes, yeah.
Yeah. Condition 6.
No comments, no comments.
Condition 7, construction transport management plan.
No comments, sorry.
Yeah, that's fine.
Sustainable travel information pack condition.
Can I just ask with the trigger point for this, just in terms of price and occupation of the development in any phase? So is it overarching travel information pack that's envisaged to cover all plots? So just wondering for consistency with how we try to approach the phasing element of it. Should it read in a phase as opposed to any phase? Does that therefore allows each plot, if it does come forward in individual reserve access applications, to have its discharge conditions in turn, rather than have an overarching one for the whole site?
I think the intention, sorry.
Okay.
I was going to say, I think the intention is for it to apply to every phase, as in it can be individually or more than one phase at a time. So to me, any phase means any individual phase. If you want to I don't object to that.
So you could do it on an individual basis or
Yes.
or as a one.
Yes.
Yeah.
Yeah, I think it's flexibility with that, it's fine.
Install cycle parking for supported accommodation.
Fine, no comments, no.
Condition 11.
Same point about the use of the word any, whether or not it's an either or scenario.
I think the way the application is constructed is that they would be all serviced plots. So therefore the archaeological work all kind of needs to be done at the same time or at the time all those works are happening. they're selling service plots, then the theory would be that all the services have been done, so therefore all the archaeological work should have been done.
But they still may come forward individually. Yeah. If they're delivering the service plot, will the servicing be put in from day one? Or will they be done in preparation for someone taking ownership of an individual plot?
Just my intention is to put the service roads in from day one. That's the practical way to do it.
So the wording of that condition would be,
So in that case, then that should be fine, if that's the case.
Yeah.
in the tree, it's a condition in terms of retained trees, approved plans.
No comments from us, I think we can do that.
And 13 is also tree. I wasn't sure if I got the full condition on that because it's
It's
within A.
worded like that.
Oh, it is.
It's a bit
Okay.
odd.
Have you got any comments on that
I
particular?
mean, we were comfortable with it in terms of wording.
I just didn't know whether there was something that came before the A. That's why I
So
was.
it does just start at A,
Okay.
yeah.
Samples of materials. I've suggested this would be covered by appearance on the reserve matters.
Quite possibly, but I've seen it on a number of appeal decisions on outlines. Yes, potentially you felt that strongly.
Well, the conditions requiring samples, would you submit samples with the reserve matters? So that, especially if you're talking about conditioning at a reserve matter stage is the other option, but
It seems unusual to apply it to an
outline.
outline to me
Yeah,
without
fair
appearance being.
Part of the outline.
Yes,
Sorry.
yes. So condition 15 relates to levels.
Yeah.
Any comments on that?
No, again, we were happy with that.
Boundary treatments, condition 16.
Is it, just wondered about the wording, just as it says a phasing wording here, I just wondered if it says the dwellings hereby permitted shall not be occupied until details of the parish units have been submitted and approved in writing. By the planning authority by phase. I just wonder if a clearer set of wording would be to say the dwellings in a phase shall not be occupied until details on boundary treatment for that phase and it's approved by writing.
Would that not be covered by appearance, layout and landscaping?
True, is the other option too.
I think technically yes, but I guess yeah, if again, I think I've taken it from outline where I wasn't part of it, but yes, I appreciate that it can be. Although to some extent, I think we've talked about the sensitivity of the site and the boundary treatment. So I think it's very clear that it sets out that there will be parameters, that there will be requirements for developers and self-builders to adhere to. But technically, if you were going down the absolute letter of outline and reserve matters, then yes. But I think it may be useful in this case if you may end up with multiple self-builders. Understanding that there are other requirements that may be on them, but I appreciate that if you wanted to remove it, we would object.
Surface water drainage permission.
Comments?
And the verification report requirement for that as well.
No comments either.
Lighting management plan.
No comments? I think there's a minor typo in the wording, actually, I haven't said that. This is prior to the first occupation of the A phase.
Yes.
That's,
in terms of water consumption. I don't know whether there's a policy requirement for that. It's not clear, or if it's covered by building regulation in any case.
Apologies, ma'am, there is a policy requirement for it, and the building regs don't cover the 110 metres. I think it's a more generous, we are in a water stress area in Wakefield, so we do have a climate change policy, possibly CC4, so we do apply it to all developments or designs.
Condition 21, road burning of waste or other materials on the site during construction.
We have comments on that.
Condition 22, by commencement of construction environment management plan.
Fine from our point of view.
Condition stating no more than 14 residential units shall be built on the site, which no more than 6 detached dwellings shall be built on the site. The remainder shall comprise flats contained within one building.
Yeah, again, we're happy with that from our point of view.
It's a condition 24, which relates to further works in terms of ecology, after the wallpaper survey, reptile cautionary method, invasive species management plan, HPI protection, ecological enhancement plan.
Yeah, that's very fine with that.
Condition 25, VNG. Although it's different in this case with it being phased, but I didn't know whether that was necessary, that being a deemed condition. Does the fact it's phased take it out, being deemed condition not required to be put onto the decision notice, providing the decision notice sets out that it is phased?
We always would apply the phase conditions. I took them from the planning advisory service, so I would suggest that they are necessary to clearly set out what the requirements are, because it is a phase and there is an outline requiring overall biodiversity game plan and all the phases.
That's how we've seen it done previously. If you feel otherwise, fine, but it follows the sort of general advice from the Planning Society. I think we're content with that. I think that flows through to conditions 26 and 27 as well.
Yeah, so you're both content with those?
Yeah.
And condition 28 in terms of a habitat management and monitoring plan?
Then
Yeah.
it's fine.
And condition 29, phase A shall be the first phase to be developed on the site.
Yeah, the only thing I'd point out about that is just the use of the word developed, that that's a sufficiently clear what the operation that needs to be completed is, whether it should say commenced, for example.
I'm not sure commenced would necessarily work, because the large attenuation tank or the surface drainage is in phase A, and if that is not built, then that will have implications, because I guess we could put the detailed surface water detail for the whole site, and then they don't build that first phase, and then we do have a
That's only in there in an indicative drainage strategy. I mean, other drainage strategies are possible. And I mean, that's
development, a full detailed drainage strategy was required to be submitted with the application. That's
You have a condition in there though, don't you, as well, for
Yes,
exactly.
Yeah, the phase discharge with the drainage details in there. So, and would the construction of the drainage tank, if it was necessary in that location, not be commencement as well? I thought that was operational development, which would actually satisfy that condition as well.
Yeah, so if it's commencement, it would be commencement. You would need to carry on with phase A, because you're claiming a sill relief for sill for social housing. You would have to build it anyway. Maybe a condition that requires the sequencing of the phasing be submitted and approved in writing by the LPA. Alternative. Because then that would marry up with whatever, if there are changes that come forward through surface water drainage details.
A submission of a phasing plan, essentially.
There's already a requirement for that.
Yeah.
We already have to do that.
No, the plan's been submitted, but there's no
Yeah.
condition that requires adherence, or it outlines, it identifies the phases, it doesn't necessarily require the sequencing of those phases.
So replace 29 with a scheme to be submitted, setting out the phasing.
Yeah.
Fine. There has to be an ability to vary that though, because if they're a self-build, you can't legislate as to when a self-build person starts. And the big concern at Waverley in phasing is still liability notices and so forth, which is why that phasing condition was originally in it, and indeed why there is a phasing plan in the form it is. So there just needs to be flexibility about, because self-build operator it's just in the nature of the beast that you don't know when you're going to start necessarily.
Presumably you could resubmit as many times as you wanted to.
As long as you can do that, it's fine.
Yes.
Okay, and then the conditions suggested by the appellant in terms of proposed site layout and conformity with the illustrative proposed site layout. The council have any comments on that?
Other than to say it's highly unusual, but whereas layout is not part, but if we wouldn't have an objection if that was in play. In the event we can't keep it, and have appeal.
Actually, that's unusual for EI development. You have parameter conditions for purposes of Rochdale envelope. So this isn't EI development, but there's a template for it. It's a tool that you can use if you think it's necessary.
And then I noticed the highways had suggested a condition. I just wanted your comments on in terms of offering £1,000 voucher towards the purchase of an electric bicycle. In their comments, presumably it's not been taken forward into suggested conditions, so I just needed to check that there was no policy basis for that, and that's probably why I've not been referred to any policy basis
They
for
cost
that.
that much in the first place, actually.
No, and there was no refusal reason for the lack of that, so I assume that was a desirable rather than.
Yes. Yeah, it's necessary.
That's all conditions that were suggested and that I found in the consultee responses. There's any other comments on the conditions we've been through? I think we've been through comments on the planning obligation already, so unless somebody's got anything to add on the planning obligation at this stage, I'm happy that I've got the answer I need on that matter.
Would you like to deal with timing on the obligation? Unilateral, I've amended, as we've discussed throughout the hearing, when I was speaking, they've been amended, it's with our team. Now,
Okay.
it will go to the council for further comments
Okay.
on it. Obviously, we're constrained by when we get that back as to when we can complete, but I think we also we can complete probably within a week to get it back. So I'm a little bit.
If I say 2 weeks,
Yeah.
does that allow you
That's plenty.
ample time?
Yeah, okay.
Is that a submission to the council or?
No submission to me.
Yes, so can we have a set time for the council to respond?
We'll have it tomorrow.
Yeah, but I'm maybe on a site visit tomorrow, so I may not be able to action it. So I'll try and action it ASAP, but I think we just need to be given maybe 4 or 5 days or something to look at it.
Fair enough.
Is that reasonable?
Maybe 3 weeks then.
If ideally I'd have it within 2 weeks.
Yeah,
but if
I will get
there's
it to you.
constraints
as
that
soon as
mean
we can.
I don't mind adding an additional week.
Should we say 3 on the basis the council wants
3
5
weeks.
days to respond? To be certain on that, I make that. By the
End of the month.
well, by 1st July.
It's a part of the turnover. You can do that.
By 1st July.
If we, I'm happy to move on to costs. A copy of the parents' cost application. Is there anything you want to add to
Yes,
that?
I'm just going to walk through it and where I've got nothing to add, I won't add, because no idea of. So the first, and I should make clear, these are drafted as each is freestanding, they have cumulative effect, but also each one's good enough in itself. But the first point, miscalculations are not being 100% affordable housing. It's accepted now by the council that custom and self-build is capable of being affordable housing subject to terms of 106. That is clearly a contrast to the position as taken by officers to members at the committee meeting. I've shown you that, and it's untenable to suggest that there hasn't been a change of position. The position put to members was unreasonable. It was plainly contrary to policy, and it's been abandoned by the council. And that's not a technical point, it's real and meaningful, because once it's accepted, as it now is, that custom self-build is capable in principle of being affordable housing subject to 106, it would have been possible in the usual way for officers, state members, you can resolve to grant subject to 106 in terms that would secure it as affordable housing, and that's planning 101, resolving subject to 106. And we now know that had that been the advice, and there then been a discussion on what the 106 should contain, that might have made a difference, because it's been said now that it's fair to characterise the council's position to you as, were this a 100% affordable housing scheme, they can't rule out that permission would have been granted. So really on the council's own concessions, they're now in a situation that wrong and unreasonable advice on policy has meant that we've been deprived of an opportunity to negotiate a section 106 that would have delivered a full 100% affordable housing and get a planning permission at local level. And that is an unanswerable basis, I'd suggest, with great respect, for reward costs, even if you're not with us all the other points on the cost application. Point number 2 is similar in the sense no legal mechanism exists to secure the self-built plots and affordable housing. Again, it's now accepted that in principle there could be such a mechanism subject to the precise wording. Point number 3, there was ambiguity at best in the officer report and the committee as to whether the scheme was or wasn't major development. You've seen references of reference to exceptional circumstances. Again, any suggestion that exceptional circumstances are needed has been abandoned, and that's clear in the statement of common ground in the council's statement of case. So once again, members were misled. I'm afraid to say, don't mean that in a pejorative sense, but they're misled, unreasonably so. Point number 4, failure to have regard to the ability to secure mitigation reserve matter stage. Again, the position of the council, as reiterated at the hearing, in great respect, is unreasonable. It's not reasonable to insist on certainty as opposed to capability. Could is enough for reasons you've heard earlier on. And it's also unreasonable, it was unreasonable of the council to take a position that there's something problematic about outline for layout and landscaping in circumstances where Article 5 requirement associated with the DMPO said that had they felt that the lack of detail on landscaping was a problem, they were obliged to seek further details, and they didn't. So there's an unreasonable tension between their position now and indeed at the time of the report and their failure to exercise the Article 5 power. I don't think I need to add to any of the other points. I think they stand, but I don't require any further elaboration on them. Thank you.
Councillors come back on those.
So in terms of the first round's costs, the council was able to consider as a matter of planning judgment whether, on the basis of the information submitted to the application, the proposal was a scheme for 100% affordable housing. Whilst the council accepts that the NPPF definition does include that such housing could be either market or affordable, doesn't mean to say that every application submitted on this basis, and considering the details of the application, that the proposal is affordable self-build custom housing. There is reference in paragraph 1.73 of the original planning statement that says it goes through the details of the discount and the sale, and then it says they remain in force for 12 months from the grant of planning permission, after which the relevant plots will be made available for self-builders at open market value with no further obligations. So based on that information, whilst initially being offered at a discount, we've discussed that at length, it was possible that, and likely that, none of the self-build plots would be affordable housing plots. The NPPF definition is clear that provisions should be in place to ensure housing remains at future eligible households. It was clear from the information in the planning statement that all the self-build plots have the potential to be sold at over the market value. And on this basis, they would not meet the definition of affordable housing. And it was on this basis that the application was considered and assessed, and the advice given to members. In response to, I think, some of the detailed points, the officer report clearly set out that 57% of the units would be affordable housing that refers to the in response to, I think there was a comment made about, I think it's in paragraph 1.5 of the costs, if you want the full. A member made a comment who refers to the proposal not being a significant part of the land which is affordable, and I think that comment is correct in terms of the actual land amount, as in that refers to the supported living units. That's a small part of the land, i.e. 30%. Amongst other things, it's clear that in the absence of an appropriate legal mechanism to secure the self-built custom plots, it didn't fall within the definition of affordable housing. So in it, not least, because obviously we've talked about the council's position in terms of the self-built custom plots and the fallback position, if you like, in terms of them being sold on the open market. But they didn't fall within the definition, and therefore the officer report and the advice to members in this regard was correct. Paragraph 1.7, the cost application refers to the scheme being an exception site, but that is not how the application was put forward. There was no reference in the original planning statement to proposed being an exception site. Notwithstanding that, the definition of a rural exception site requires affordable housing in perpetuity, and the perpetuity requirement at the very least met. Council doesn't consider it behaved unreasonably in relation to its officer report and the advice, as the advice was based on the specific details of the development. Mention has my last point on this part, and then the others are quite quicker. The point has also been mentioned that if the council had an issue with the precise terms of section 106, that it could have resolved grant planning permission subject to a satisfactory section 106 being completed. However, applications can be considered on the basis of the submission and there was no clear way of providing an acceptable agreement to address the council's concerns. And also, such comments imply that obligations or headroom terms don't need to be agreed with an applicant before an application is considered by a committee, which is contrary to the advice in the planning practice guide. So you've been able to have gone to committee to resolve to ground subject to exceptional consent if you haven't agreed to terms. In terms of I think it's the second round of costs. About there being no legal mechanism to sort of secure the self-built plots forward by having, because of the backstop, there is still no legal mechanism. You will still allow those plots, one or all of them, to be sold on the open market. Major development point, we have accepted that the scheme is not major development in the Surrey Hills National Landscape. 2 previous appeals, as we've heard, have been dismissed in terms of the impact on the OMB, where they were not considered major development. With regards to, I think it's number 4, ground 4, the failure to have provided the ability to secure landscape mitigation. The impact of the proposal on landscape character is a matter of plan judgment. Paragraph 4.1 of the costs refers to, it's page 201 of the officer report, but so that would be page 201 of the agenda of the planning committee officer report, because they're not normally numbered. So suggesting that members would advise that landscape mitigation could not be taken into account. However, on reading of the officer report, it doesn't suggest it can't be taken into account, only that the landscape proposals can't be secured at the outline stage as they're a reserved matter. And this text is provided at the end of the paragraph assessing the impact on the hedgerows and noting that reinforced hedgerows were proposed. Again, paragraph 3.3 of the original LVIA suggests that the hedgerow could be enhanced. We discussed about the words, use of the words could and enhancements. And I think last point on this section is it's correct that an acceptable development cannot be made acceptable just because it's well screened. Otherwise, this would serve to enable all unacceptable proposals to be granted plan permission just because they're well screened and encourage planting before submitting proposals that are contrary to policy. In terms of, it's interesting to find. Relating to the nature of the self-built plots. So whilst the application is in outline, this is incorrect because the original planning statement submitted with the application referred to 4 or 5 bedroom self-built plots. They also recognise that all dwellings should meet the nationally described space standards for which 4 or 5 bed plot, or sorry, for which 4 bed plots can range from 97 to 124 square metres, of 5 bed dwelling 110 to 128. The indicative plan shows footprint of a proposed dwelling with an attached garage. So they will comprise large detached dwellings on large plots, and the paragraph 2.98 of the original planning statement sets out that the proposed dwellings can easily exceed the ministerial space standards. This section of the costs also suggests the officer failed to draw attention to the fact that the application was in outline. However, the officer report clearly sets out that the application is outlined with all matters reserved. Final ground in terms of ground 6 refers to a comment about Surrey Wildlife Trust. From reviewing the file, there was no updated consultative response from Surrey Wildlife Trust in response to further ecological information at the time of the meeting. And there were, in the costs it claims, there was an implication that there was an unresolved issue. That clearly wasn't the case because there was no recommendation for refusal based on ecology grounds or any suggestion of a deferment of the application to await the solar applicant's response. This information did not impact the decision made or any consequent impact on the appeal process. And on the basis of the information, the council does not consider it's acted unreasonably, either procedurally or substantively. An application during due to the harm and the nature of the proposal being refused based on the details submitted at the time of the application. So an appeal can be avoided.
Madam, thank you by way of reply. On heading number 1, affordable housing, it said that local authorities exercising planning judgment. But if I can invite you just to turn back to paragraphs 1.3 and 1.4 of the concept application. This wasn't planning judgment. This was approach and interpretation of policy. See the quotes there. The description in the NPPF doesn't allow them to be affordable housing. 1.4, you can't have self-built as affordable. And that's not the exercise of planning judgments. That's advice to members on approach, interpretation of policy, and it's fundamentally wrong. Because the NPPF says in terms, custom self-build can be affordable housing, and that's accepted now. So this isn't planning judgment. It's a fundamental error of approach. It's not right as well, not adequate then to say, well, the application has been determined on the basis of what's submitted. It's standard practice to consider the principal development, and then the details of any section 106 are left to negotiation, subject resolution grant, subject to satisfactory 106, and the resolution will specify the heads for the 106. Given that the council now accepts that it was wrong to say NPPF doesn't allow for affordable housing, given that the council accepts that the custom self-build could in principle be affordable housing subject to terms, it was unreasonable not to tell members that, and it was unreasonable not to give members the opportunity to resolve to grant planning permission for a 100% affordable housing scheme, subject to whatever officers and the members considered ought to be the ingredients of 106. And as I said, we know the exceptions point is a red herring. What we do know now, very clear, is the council accepts that had that been the advice, they can't rule out members with a granted planning permission. And that's very clear from the transcript as well. So again, you see the quotes there. For example, Councillor Spence called this the most compelling consideration. Indeed, the council said it may change his judgment. So this fundamental failure to give proper advice on capability of customer self-build to be affordable housing, and then to set out what officers thought was necessary to go into 106 to make it. So that is the same point in relation to issue 2 as well. The point made about customer self-build, it couldn't have been affordable housing because of the backstop. That's ultimately all about the section 106 mechanics. In relation to point 3, appears to be essentially conceded the council, the Office of Court did wrongly refer to the exceptional circumstances test. In relation to point number 4, failure to have proper regard to landscape mitigation, again, it was said that this was planning judgment by the local authority. It's not a matter of approach. Quotes there at paragraph 4.1 of the cost application. The approach taken was that because details haven't been submitted, because the landscape details can't be secured, therefore the effect can only be assessed as adverse. You don't have regard to the mitigation. For the reasons I've given, that was wrong as a matter of principle.
The question was, could accepted landscaping in principle be capable of coming forward? And if to make that judgment, the council felt it was necessary to have a full details of landscape, Article 5.2, the DMPO gave them those tools and they didn't use them. So that's not a planning judgment, that's approach, and it was an unreasonable approach. In relation to point 5, the size of dwellings, the indicative plans indicated, as indicative plans do, particular scale, that any reasonable officer and any reasonable council would have appreciated that the ultimate scrutiny of the size, scale of the individual dwellings was a matter of reserved matters. And therefore, to describe the self-build units in definitive terms as necessarily large detached properties or large plots is a misdirection. They were capable of being otherwise, and if that was considered to be necessary, conditions could have regulated that. I don't need to elaborate on the Surrey Wildlife Trust. It seems to be accepted that it was misleading advice, but suggested it didn't go anywhere. Claiming it was translating the reason for refusal was at a piece with what I'm afraid to say is a fundamentally misleading approach taken by officers, both in the report and at the committee. And I don't mean to say it anyway pejoratively, but I hope you can appreciate, I don't know if you can't comment now, but appreciate why Mr. Lawson feels very upset at how this has been handled and has been put to considerable expense unfairly, and it should be entitled to recover that.
Does the council intend on submitting an application? Turning now to site visit arrangements. It's getting very late in the day today. What is everybody's availability like?
I'm available tomorrow.
Tomorrow.
Excuse me, looks like if Mr. Cook's unavailable tomorrow, so.
I mean, I'm available to do it now, but I appreciate that it is getting late on in the day. And you
I
may
can
have
do it
to-
now.
You can do it now.
If you don't mind,
That's
I
fine
would
by
much
me.
rather have Mr. Cook there because he is the expert for our side.
Absolutely. Appreciate that, as long as council are able to.
Thank you.
Yes, I will probably need to let somebody know when we finish the site birth. It's company short. Someone can count me. Yes,
I'm
yeah,
sure you'll be safe.
yeah, it's just making sure that our internal procedures are
Yeah.
Follow.
followed. So, yes, I'm happy to do a site visit.
Okay. About half an hour
About
away.
half an hour.
Yes.
In terms of parking, are we able to park?
Yes, in front of the main house,
Okay.
there'll be car parking there after this time of day. The people there will have left, or most of them have left.
Okay.
Probably worth Mr. Lawson being there. I mean, Mr. Lawson knows the rules in terms of
Absolutely.
site visits, but because you've done a few before, but I think
Yeah,
it's worth you being there.
I won't say, but I'll just direct you around, so it's a bit, did you bring your boots?
Yes.
Well done.
Prepared.
It's been a bit muddy. Have you got your boots?
I have got mine. Can I just ask, is Hedgehog Lane still closed at the bottom?
No, it's all
Oh,
over.
is it all over
Yeah,
again now?
Yes.
Okay,
It was for a long time.
yeah, well,
Is it easier to park in front of the main house or on the construction compound?
We can go into the construction compound, which is
I was
used.
just thinking, then we're on the site and
Yeah,
then we can walk up on that.
so Madam Inspector, when you drive into Longdean House, there's a large driveway. You take your first turning through some big blue gates, and there's the construction site. That's all. It's down to, it's got hardcore down there. It's dry. That's okay, but
Okay.
and then we can walk. I'll just show you the way around roughly, but as I say, I'll leave it to you to ask. any
And then
questions.
you're actually on the site, you'll do that, and then we bring you up the access road. And we can see the rest of the residential.
Yeah, we're okay to walk around
Yeah.
the rest of the residential around Longdean House.
Yeah.
Not within the curtilages
No.
per se, but you can, yes, you
Around.
can walk around comfortably.
We agreed
impinging.
a path around actually, which is safe.
Yeah.
It is a building site, but that's screened off, as it were. And everything else is, I consider safe.
Okay,
It's perfectly accessible.
so if we allow 15, 20
Gotta get
minutes
to the
to
cars.
get ready to leave and then
Half
half
five
an
is,
hour.
half five is probably realistic.
Is it half
I'd
half
thought.
five?
I think you've
That's how
got
fast you
a
drive.
lot of luggage there. I would suggest you give it an hour. Yes. And it's also rush hour.
Yes, that's fine.
Quarter to 6.
On that, and just picking up on that, I'd suggest going up the hill towards Midhurst and turning right into Portsmouth Road rather than going anywhere near the station, because there is a very long traffic lights by the station at the moment.
Go up Shepherd's Hill.
Yeah, up Shepherd's Hill and right into Portsmouth
Yes,
Road.
don't turn right past the station, go straight up
Yes,
the hill.
exactly,
and then turn
because
right.
that traffic lights will be
Okay.
hell on earth at this time, I think.
If you put Portsmouth Road in your satellite system, it'll be better.
Portsmouth.
Portsmouth, yes.
Ports Hill.
Sorry, Courts Hill.
Yeah.
So if there's no other comments from everybody, thank you all for your contributions. The hearing is now closed. I've got everything.
Am I? Yeah, I am. Yeah, because I've got to get the feedback. Oh, well, you
I'll try for that.
Sorry. Yeah. No, I'll go thank you.
Okay.